आता बोल अरे उधर कैमरा आ रहा है सर, कैमरा आ रहा है ना?
और कैसी चेक 1 2 हेलो।
अभी इसका होस्ट किधर हो आप करोगे? इसका होस्ट बनवा लागेल ना.
Good morning, friends. And well begun is half done, it has been said. And starting on time is important aspect. And we have a wonderful program ahead. And joined us online. Of course, that's something which has been taught to us by COVID, that we can do a lot of things in a hybrid manner. And we thank the vision of our president to have this as a hybrid program today. And we have this wonderful program coming up. To start the ball rolling, let me have the pleasure of introducing a man who needs no introduction, Dr. Hemant Dugar. He is a practicing gynecologist and obstetrician since 1985 with a multi-specialty hospital. And we all know him as the honorary secretary of AMC for this current term. He was an ex-honorary assistant professor at Cooper Hospital and has been working and is still working with Lions Club International since many years, and has been working with Punarvas Special School and was the district governor. So Dr. Hemant, we welcome you to take the proceedings forward.
Thank you, Rina. Good morning and welcome to you all to this wonderful program on medical legal issues from Association of Medical Consultants, Mumbai. Once we welcome our chief guest, Justice Thavde, also with us. The president of USA once said that if we can reduce the 1/3 lawyers in USA, we'll be able to reduce our deficit by more than 50%. Well, we in India, we haven't reached to that stage, but definitely and surely we are following it up. And as more and more rules, regulations, they are implemented, the doctor community is aghast and troubled with a fear of medical legal issues all the time. I mean, it's more than attending to the patients. We are more worried about not getting trapped into the legal tangle. And to address such issues, Association of Medical Consultants Mumbai has been always in forefront. This year, our president, Dr. Nilima Vaidya, who is also a law graduate, she is she's been secretary for it's not come, but she's been secretary for AMC consecutively for 2 years. She's vice president of Kandivali Medical Association, founder member of Mumbai Dhadkan, secretary of Being Doctors, ex-member of Medical Legal Committee Foxy, Best Speaker Award at a state level moot court competition, Best Student Award at Nalanda Law College, and a gold medalist at DJU exam. I hand over and welcome our president, Dr. Nilima Vaidya, to give her welcome address. Dr. Nilima.
Hello, good morning to everyone and each and every M side who has joined in today. A very, very warm welcome from my side. Today we complete 8 months in office. 27th of March is when I have taken over. Today is 27th of November, 8 months. 8 months down the line, we have stuck to our guns and done every program with a theme. We've completed nearly 16 programs and today is our 17th program. We're just halfway down the line and a lot of interesting things coming up, which Reena is going to talk to you about. And I'm very, very happy about the medical legal conference today that we have. This is one of the flagship programs of AMC. AMC, the strength is the medical legal team. And today we bring to you various topics. In the brochure, you can always see that we are dealing with nearly everything, right from criminal proceedings to cybercrime to Consumer Protection Act, and then a panel discussion on whatever questions you may want to ask us. So let us start this program, and I hand over to Dr. Reena Vani to tell us about the upcoming programs that AMC has planned for you. Thank you.
Thank you, President. And it's my proud privilege to introduce to you our program committee chairperson for this year, Dr. Reena Vani. Dr. Reena Vani is professor and head of the department OBGY at HBT Medical College and R.N. Cooper Hospital, Mumbai. She is the program committee chairperson for this year at Association of Medical Consultants, Mumbai, member of Foxy GCPR for COVID Guidance and Vaccination 2021, President Mumbai Breastfeeding Promotion Committee 2019 to 2022, Core Committee Foxy Violence Against Women Cell 2015-21. She's hinting me that no, don't go ahead because there's a huge list. But that's what is our program committee chairperson. Very efficient, not only at Cooper, but in our AMC. And we are really proud to have Dr. Reena Wani. I ask her, request her to take it forward.
Thank you, Dr. Hemant and Dr. Nilima, for the kind introduction. You know, friends, it's been said there's a brave concept, do or die. A practical concept is do before you die. A winner's concept is don't die before you do it. And each of us has to make that choice. And our dynamic president, Nilima, exemplifies choices that have never been made before and has boldly rushed in where angels fear to tread. And we have done new and new programs. You already know what has already been done, but my job today is to tell you about the whole series of upcoming programs that we are having. And we have a medico-legal series. In fact, today, this program is going to kick off the inauguration of the medico-legal series, which Dr. Vidya Shetty will be convening with our team, starting from the 4th of December. We've also already done a FinCon 1, which was on financial management and financial health for doctors, which is going to be continued with FinCon 2 and 3. And the plan is to have FinCon 2 on 25th December. We have different programs coming up, like, for example, Bikeathon. And we have a lovely set of lady bikers led again by our dynamic president who are going to lead the way. And this is planned for 26th January. On 29th of Jan, we have something again very different. Ashwin Gidwani from the theatre will be doing a program called Black Tape, which is a silent humor comedy. And I would encourage all of you to please take benefit and do come and watch this program. Well, February also is going to be a very dynamic month for us. Digitalization is the need of the hour. And in the first week of Feb, we are planning a DigiCon. On the 12th of February, we are planning ITCon. And later on, and is very important, our flagship event for the year is going to be Mlcon. The theme is Astitva. And in that, we are having 2 days. The first day of 25th February is Fitness for Fraternity, which has also been Nilima's theme. We've already done a walkathon, a cyclathon with Rahul and Ajay Haryani working on that. And on 26th Feb, we're having something called Ek Zindagi Aisi Bhi, where doctors are doing different things, and those are going to be the special speakers. And last but not the least, of course, there's going to be other stuff along the way, but Women's Day, 8th March, is going to be celebrated by a car rally. And yes, we won't keep it only for women. We'll encourage all our members to be there. So friends, I promise you, there's going to be a lovely year coming up for whatever months are left. And in the words of Robert Frost, the woods are lovely, dark and deep, but I have promises to keep and miles to go before I sleep. Miles to go before I sleep. Thank you so much for being here with us today. And now we take it forward by starting with our session. And again, being hybrid, we are going ahead with the first topic on a digital platform. This topic is called Dealing with Nuances and Adverse Impact of Social Media on Doctors. It's not just doctors. You must have seen it in your families and children, the impact of how many likes did you get on Facebook? Did anyone see my WhatsApp? Why has the blue tick not come? And we have a wonderful speaker for this. We have Dr. Harold DeCosta. He is the president of the Cybersecurity Corporation, advisor for law enforcement agencies, and currently the president and CEO of Intelligent Quotient Security System. He's an advisor and international trainer for matters related to cybercrime investigation, cyber forensics, digital evidence, cyber law, and cybersecurity, with vast experience in corporate, education, and government sector, and has dealt with matters related to cyber terrorism, fraud, data theft, etc., etc. He has a rich experience of more than 7,000 cases and has trained more than 40,000 cops in our country. And he has had training of judicial officers across the Southeast Asian region and in the USA. Friends, this wonderful speaker was a resource person already for 27 international conferences, part of India Mobile Conference, and has set up Social Media Lab for Pune Police. And we're very happy to have him here. He's already had a 5 times consecutive award for his exemplary work. So we are looking forward to hearing what Dr. Harold DeCosta has to say about key points and preventing medical legal problems. So we'll go ahead with his recorded lecture now, and if we can play that. A recorded lecture, sir. No, sorry. Harold DeCosta ka hi hai. Yeah. We have Pranav from the team Finovate, who's been our techno-savvy person. And thank you, Pranav. And if you can get the ball rolling,
Good
literally.
morning, everyone. This is
Thank you.
Karima Sankeshwari here from Cybersecurity Corporation. I shall be conducting the presentation on behalf of Dr. Harold DeCosta today, as Dr. DeCosta had to leave for a conference for National Judicial Academy. So a very good morning to everyone. Our topic for today is a very interesting one, and I think we all have been using it since a very long time now. Social media, the offensive attacks as well as the preventive methods. Firstly, let me talk about a little about the internet. The first thing which is majorly very important is our internet is not owned by anyone. Since it is open to all, when we talk about data security, it is a very big question which we talk on. There are total 13 root servers around the world. These root servers store all our entries, our data, and in case of an investigation, when the data is required, it is normally required from these root servers around the world. India does not have a root server currently. We have applied to ICANN, but we are yet awaiting a survey from them and a result after that. Initially, when we did apply, they asked us to convert our IP version 4 to IP version 6, and that has been happening gradually. And let's hope that we get a root server at the earliest. Once we get the root server, our investigation team will get a lot of support in finding out from where these crime frauds have been taking place, and easier to trace and track the culprit. Now, when we talk about social media, we currently have our accounts on various social media platforms, be it personal or for business purposes. Regardless of age and gender, people are signing up on online social networks for personal as well as business opportunities. Often, social networking platforms are used for fake profiles, spam legitimate users, posting inappropriate or illegal content, misrepresenting renowned person, and posting fake news to cause harassment to him or her. The social networking platforms were made for the purpose for people to come together who share a common idea and can help each other out. But as we have started using social media, there are always a few cons which come with each and everything. So the cons which come with social media are the fake profiles and the spam legitimate users and so on. So when we are talking about these cons which are there, we need to be aware. We need to have a basic knowledge of how we should not fall for such scams, or we do not become an party to a fraud happening with us. Now, when we talk about healthcare, 1 in 4 doctors experience hostility on social media. This hostility which we are talking about can be on various grounds. It can be regarding a fake profile, a fake review, negative reviews, a lot of other things. As per the statistics in 2021, you can see that 94% of healthcare patients use online reviews to evaluate the providers. So nowadays, patients have become more and more self-aware and would like to, check for their symptoms beforehand before going to a doctor. They are many times when people are already have an idea about what kind of a symptom they have in a disease it may be related to. But whatever information we get on the net is not always secure and not up to the point as well. Therefore, when we talk about doctor reviews, it is very important that all the patients 100% do check the review before coming. But how good the reviews are is not necessary, or how bad the reviews are is not necessarily the truth or the facts of that case. There was a survey which revealed that rape and death threats were among abusive messages sent to doctors on social media, while 1 in 6 female respondents reported receiving sexually harassing messages. Due to social media, this has been on the rise a lot. Each and every person who is on social media needs to see that the privacy settings are updated to the latest mark, because currently the way social media is being exploited by the I won't say hackers, or I can say culprits who are specially doing this to cause harm to the society at large. Why social media is a valuable tool for healthcare? As we can see that 41% of people say social media would affect their choice of a specific doctor, hospital, or medical facility. So it is really important that each and everyone has a social media presence, but up to what level is very important. As we saw in the stats going ahead, that 80% of social media users have looked for health information online regarding diseases, procedures, and healthcare professionals. As I said before, nowadays patients always check such things before going to the doctor and then will give their own inputs and try and be superior. So this is a factor which has been faced by many doctors recently. A few doctors which have visited us on various different cases have also spoken on that. And there are a lot of other doctors who would like that opportunity also to talk on this topic and to make the public aware that whatever we read online is not necessarily what is true, because each and every symptom is different. Going ahead, 60% of social media users trust social media posts by doctors over any other group. Going ahead, the percent of healthcare consumers that ran a search for scheduling an appointment. Now, in this, as you can see, that healthcare consumers ran a search before scheduling an appointment with a certain type of a doctor or a clinic. So, when we talk about chiropractors, 61% people first conducted a search for them. Same way, 67% for clinics, 71% for dentists, 69% for hospitals, 79% for nursing homes, 74% for optometrics, 84% for physical therapists, and 71% for physicians and surgery. Therefore, any person going to a clinic nowadays will always prefer a search, and this social media is a tool which can be a bane or a boon. So, what are the nuances which we face on the social media? First one is the fake profile creation. So, creation of a fake profile of a person and posting offensive content, including mock photographs on the fake profile. The most common targeted website apps for creating fake profiles are Facebook, Instagram, Google, Twitter, and Snapchat. In this, a lot of cases have come up where fake profiles of various doctors, various film actors, various people who are renowned has been created, and people are falling into a scam through it. Now, when we are talking about this, not each and every one has a social media presence. There are few of us who would prefer to not keep everything on social media. There have been cases where people do not have a social media platform account at all. After this, once someone tries to create a profile, and once he creates the profile, images is taken from Google. Using that, a profile is created, and once that is created, a few details about the person are written, and the profile is active. Once it is active, various friend requests, various requests to other people goes through the profile, and then these people ask for some or the other financial help. They may ask for help because they are stuck up somewhere, and in turn, it will lead to a financial fraud. This was about financial fraud. But the same way, it can even cause defamation for various people. Because once the fake profile is created, and in case he's asking for a financial help for many people, it can even be defaming for a person. We'll talk about a case study of a fake profile. Since we are on the doctor's forum right now, I will take a case example also, which has come to us from a doctor. This doctor is in Pune and he's a very famous child doctor, pediatrician. So, what had happened in his scenario was that a fake profile of his was created on a matrimony website, and various details were written about him. And post that, a lot of requests had gone to various women. They had started, they had accepted that request. There was a little bit of communication in between them. And later on, when it was revealed that actually that person is not him, and these ladies started blaming the doctor for having made this profile on the matrimony site. So the doctor went to the police to file a complaint, and he had to go through a scenario of nearly 6 months to find out who the culprit was behind it and to get himself out of that racket. So this fake profiles can create issue for anyone. From it can be a doctor, it can even be a nurse, it can be any medical professional, or it can be anyone who's into a security field as well. Another major social media nuance is negative feedback and reviews. Fake patient reviews are making it increasingly hard to seek medical help. Posting fraudulent reviews may be illegal if there is financial gain involved, but enforcement is scattershot, and it is hard to find cases of disciplinary action from professional bodies for review fraud. Everyone nowadays wants to review about the type of treatment or service they have received. Each and everyone also forces their patients or their colleagues to write a review about them, a good review about them, or a frank review about them, just so that their social media presence goes up. Now, when we talk about the negative feedbacks which come with it, in that I'll take a case example of a fake feedback fraud which has happened recently. In this, what scenario had happened was, recently a lady had visited a skin doctor for help. After after her appointment and all, she had a few queries from the doctor. Now, she, I think, WhatsApped him for a few inquiries. Post that, since there was no reply for around 1 hour, 1 hour, 15 minutes, she started posting negative feedback about the doctor. And her posting the feedback was one thing, but what she did was she got her whole family into it, her friends into it, and people who had not even visited the doctor or his clinic started giving a negative feedback. And this is what a very big nuance on social media is. There is no way to verify whether the feedback being given by a person is actually genuine, or is it someone who's giving a negative feedback just for another person. Because there have been many cases in which restaurants have faced a lot of backlash from people just because of one person. They went for a party and they may have had some issue out over there. Post that, a group of 20-25 people give negative reviews on Google and try to defame the restaurant. Same way this happened with the doctor's clinic. A lot of negative feedback from her friends, from her family were posted up on Google, which created a little bit of a shock for the doctor, because what happens is 1 hour 15 minutes to reply back is a very short span of time. And as per my understanding, there is a medical law in which it has been stated that the doctor has up to 48 hours to reply back. So he was well within his stipulated time when he replied back to the woman. In around 3.5 hours, he had got back to her, but still this woman ended up making a very big nuisance for the doctor. Later on, the matter was sorted out. She deleted her reviews from Google, and she asked her friends to do so. But this is what a negative feedback can do to a person, because it may affect his image. The latest ones which are ongoing a lot are the sextortion scams. These scams are mainly targeted to all men who use Instagram, Facebook, or WhatsApp because a fake account is created, and using this account, a woman will from the member will send a message to the victim. Hey, hi, hello, how are you? A normal conversation starts, and once a conversation starts, she'll try and get him into coming onto a video call. And as soon as he accepts the video call, she is either starts stripping and she encourages him to do so, or she may be nude from before, and she screen records the complete conversation which happens, and the man has no idea behind it. After this, as soon as the video recording is over and the call is cut, within half an hour's time, these recordings as evidence, the gang will start to blackmail the person. And in this, a lot of people have fallen for it because various times, since our numbers are available on the internet freely, there have been many instances where the doctor faced an issue where he received a call for help. He was told that she's not being able to explain the matter to him pretty well. She would like to video call him to explain the symptoms, and the doctor accepted the video call. In 4 seconds time, the doctor cut the video call as well. As soon as he saw that there are nude images in front of him, objectionable content, he directly cut the call. But these 4 seconds of recording was enough for the full gang to blackmail him. And after that, the whole scenario started. He started receiving messages on WhatsApp saying that this is your video and we'll be sharing it with your friends and family, and you have to pay up this much sum, and so forth. After this, the doctor ended up paying a sum of around 25,000 rupees, after which he consulted the police, and the police started investigating the matter. But in such scams, what happens is very few victims lodge complaint because of embarrassment. When we come on to a case study for sextortion, as I told you about one doctor, there are various other case studies which have happened with many industrialists as well. It has happened with many people who are in the media as well. Recently, a person who's into media coverage had faced the same issue, in which he received a call from an unknown number, and after a few minutes, they said, "We will video call you," and post that a video call came. Once the video call came, the man accepted it. The problem of a video call is that as soon as you accept the video call, it is normally your face which is directly shown onto the camera. And it takes our brain minimum 2 to 3 seconds to cut the call. And in this 2-3 seconds are enough for the gang to get your face and try and morph it onto other images as well. Now we spoke about the nuances, and now we'll try and talk about the prevention methods which go with it. How to recognize fake Instagram accounts. The best way to understand what a fake Instagram account may look like is you have to look at their profile picture, you have to look at their followers and followings, you have to look at their posts, their comments, and whether they are using their own images, or let's say they have around 10 posts. In these 10 posts, if they have posted images of around 7 different people, it is a clear-cut signal that this person may be fraudulent. Another thing what needs to be looked at is how old of an account is that? Is it a brand new account? How much has it been used? When was the first post made? And if they are offering massive discounts or sales on their Instagram page. Recently, there have been a lot of instances where people have posted online that a various product, which is just for around, let's say, 10,000 rupees, is being sold for just 1,099. So this becomes as in humans, we do have a greed factor. And when we see that we are getting a discount of nearly 9,000 rupees, everyone rushes to get it. And this is where various people fall for the financial fraud. This is how we can recognize the Instagram fake accounts. As you can see in the first picture, there is no DP onto it. After the DP, when we go on to the next one, as you can see, the DP is there, but it does not belong to that same person. As well as the number of followers and following is 0 as well. Coming on to the third image, you can see that there are various posts of different entities on this in the Instagram profile, not of the same person. There are various different people who are there. Fourth one is there are no posts at all, and there is no DP at all, and as well as the followers are 0 and 0. And the another one is the discount one. Now we'll talk about fake WhatsApp messages. It is very important to understand that even WhatsApp messages can be spoofed. And the best way to recognize a fake WhatsApp messages is to select the message on your Android or your iPhone. And on selecting the message, you can see in the red box, these are the options what we get: star, reply, forward, copy, info, speak, delete, as well as on the top, the emojis which come with it. If this is what comes to you, you are safe. This message is a genuine message. But in case when you select that message and an option of something like edit text or edit message comes, that means that message is a spoofed message. Same way for Android, in the right picture you can see once you select a message, you get the symbols on the top, which is basically forward, star, delete, reply, and more options. Same way, in case of a fraudulent or a fake message, edit text is what will come on top of it. How to recognize fake and negative reviews. So analyzing the language and looking at the complexity of words is very important. There have been many reviews in which people just give 1 star and don't write anything ahead. There are various reviews in which the language of what is written is very repetitive in 2 to 3 negative posts. Obviously, they are from different person's name, but the post matter is nearly the same. You have to even examine the reviewer's name and avatar, whether the person who has commented who has reviewed is actually a genuine person. You also need to check whether the reviewer has reviewed other businesses. There have been many instances where people just open you can say a Google account or a Instagram account just to leave negative feedback of one person and then don't use that account. So it is very important to even understand whether a person who has given a negative feedback, has he been reviewing other businesses? And if he has been reviewing other messages, has he been reviewing everyone a negative review, or he has given positive reviews as well? And we even need to look at the frequency of the reviewer, how regularly he leaves the messages. The steps we have to deal with for online abuse and harassment. We need to keep a record of the messages or posts, and we need to identify the patient that may have done it. And we need to collect and record any other information that might help later. In case of a fraudulent review, we need to take a picture, a screenshot of it, and save it with ourselves. In case of a website, we need to download the website and calculate the hash value and keep it with us as a ready evidence to use it ahead. For the reporting part, we can report any online abuse onto the cybercrime.gov.in portal, which has been started by the Home Ministry. And you will get a call from the law enforcement asking you to come and give your statement as to how the matter happened, and they will start investigating the matter ahead. You even need to report this abuse to the platform provider, be it Google, Instagram, Facebook. You need to report this type of scenarios to them as well so that they can take action. Few important sections of IT Act 2000 which nearly need to be looked at, and the most important one is Section 66E, punishment for violation of privacy. Followed by that, Section 72, breach of confidentiality and privacy. These sections you can go through the present. I'll be sharing the presentation with Lalit sir, and surely you can take it ahead. Securing the workspace. So what are the few factors which are required? That is, we need to educate our staff on data security, and we need to implement physical security also at our workspace. We need to have key cards in place so that no person except for the authorized person is entering the premises. We need to see that the data which is stored with us is encrypted at rest and in transit with decryption tools stored on the device. Many times our data which is stored on a server may not always be in encrypted form. Therefore, we need to encrypt all our data which is there. We need to restrict access to data and applications, especially no sharing of patient data via social media. Sharing of any document on social media is not secure. Let's take a medical report, for example. A medical report can be edited. Let's say take a PDF file, for example, in which normally we get our PDF reports, our blood test reports. It is not necessary that that cannot be edited. So we really need to see to it that whatever files or data which of patient which we receive, whether it is authentic in nature or not. Implementing data usage controls, logging and monitoring use, securing the wireless networks, and conducting regular risk assessments, utilizing offsite data backup, and securing mobile devices. It's very important to secure all mobile devices in your clinic or in your workspace because they are the source through which anything can happen these days. A little bit about our company. So we have been a flagship company providing techno-legal solutions in the cyberspace domain. We have worked with various law enforcement agencies and judicial system as well. We have been given expert opinions as well as we train the judges on digital evidence, which is the key subject. CSC also has a pool of experts who provide their opinion and help organizations to detect and investigate and protect their networks for unauthorized access. It also caters to other verticals, especially in the corporate, government, semi-government, and non-government organization in the country. We are a one-of-a-kind organization that provides techno-legal solutions in the cybercrime domain. We have worked on more than 7,500 cases of cybercrime from 7 countries worldwide. These are a few services which we provide. These are our partial clientele. We have worked with National Judicial Academy, Maharashtra Police, Goa Police, Income Tax Department, Air Force, University of Mumbai, and so forth. So thank you to the team for helping us make this presentation possible without Dr. DaCosta being present there. And you can obviously contact sir or write to him in case of any queries, and he shall surely get back to you in case of anything. So thank you very much. I hope this session was informative and would help you ahead. Thank you.
Thank you. Thank you very much. And to convey to Dr. Harold DaCosta that we appreciate his efforts.
From Cybersecurity Corporation.
So thank you very much. And it was a wonderful session, bringing small points which we use our social media, but we are not aware how important it is. Now I'll request our senior trustee and chairperson, social service cell, Dr. Ajit Desai, to come forward and introduce Dr. Jayant Navrange and Dr. Ajit Desai.
Hello. Good morning, everybody. It gives me a great pleasure to introduce a well-known pediatrician from Pune, Dr. Jayant Navrange. Dr. Jayant Navrange was a brilliant student in his medical career, and he received gold medals in MBBS, MD, as well as in DCH examinations. He didn't stop there. He went on and did his LLB, and there he stood fourth in the examination. He is an honorary pediatrician attached to Srivatsa Hospital, Sasun General Hospitals, Bhatia Samaj Seva Kendra, Pune, Dinanath Hospital, and the Sahyadri group of hospitals. In fact, he is having such a huge number of achievements that I will not be enumerating each and everything today. Only few I can enumerate. He was a past president of IMA Pune. He was a past president of Indian Association of Pediatricians, Pune, as well as Maharashtra branch. At present, he is a vice chairman of Medical Legal Cell, IMA headquarters, and he has helped many doctors so far. He conducted even one course of medical legal for IMA. He is a visiting faculty in ILS Law College, Pune. He is having plenty of extracurricular activities on his name. In fact, he has participated in more than 26 marathons and the cycling competitions also. He is a good regular blood donor and he must have donated more than 65 times so far. He is a recipient of Bertha Holt International Awards for rehabilitations. He is the chairman of Indian Medical Association Social Service Scheme from 2018 to 2023. And he is having a lifetime award of IMA Pune for 2021. Understand? I will ask Dr. Jan Nawarangi to give a speech at this precious occasion. Thank you.
Thank you so much, sir, for a very nice introduction. ANC on the organization, Dr. Vaidya, Secretary Dr. Dugad, and my respected teacher and mentor, Dr. Lalit Kapoor, is the diligent record keeping. It's nicely worded. Key importance of diligent record keeping. So I will start with sharing my presentation. I hope, am I audible? हॅलो मी मॅक्सिमम ठेवलाय आणि आय एम शेअरिंग माय स्लाइड्स ऑल्सो जस्ट अ मोमेंट I did, but then it's taking some just yeah, that's a problem, yes. Just let me try for a minute. Can I do one thing? I will send you this slide presentation just across. Okay. 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 You can see the slides. Okay. I will start. Okay. Teachers and good morning, my colleagues. And she drafted as diligent record keeping, the importance of diligent record keeping. So I will go to the. So this is a good definition, very good definitions, but I like this one very much. Is that given by McBinney in the scientific, educative, and a legal document relating to the patient care. So I think each word is important. It's clinical record, it's scientific record, important from administrative point of view, educative, and a legal document. And it is all related to the patient care. I would be giving an upgraded touch because most of the times we have the computerized record. So in
problem
manner.
Other side. So, but I'm sure the talk will definitely give us a lot of valuable inputs. The first talk on cybersecurity, I think, has opened our eyes to a lot of problems I'm sure all of you have faced in different manner. And we've always had fake friend requests or double friend requests on Facebook. And although Dr. DeCosta's presentation did give us a lot of clues, I'm sure a lot of you are still a little worried how we'll be able to separate the two. So now we've got the, are we getting audio now? Let's try this.
Should I start? Can I continue?
So the slides are coming, but his voice is not coming.
Okay. So meanwhile, while we are waiting for this audio to come, the technical part, I can, regarding the previous talk, I would like to give you one example which happened with one of our members.
Hello.
Again, it's a warning to our members. So one day early morning, this doctor came to me, 8 o'clock. He was very upset. He and his wife came and he said that he had been referred one patient, but from Just Dial, you know, this Just Dial, they refer patients. So this patient, a young lady, she had piles and he put her on the examination table, examined, and the lady had huge piles, very big piles. And so he told his nurse loudly, he said, "Sister, Jara, please take a photo of these piles. You know, please take a photo of these piles." And that lady did not say anything. And the photo was taken. And once she got up from the table, she started shouting and yelling, "How did you take my photo without my permission?" He said, I said so loudly. She said, "Nothing doing. Why did you take my photo?" So he said, "Just to show you how bad your piles are, because you can't see your own piles, just to show you." She said, "Nothing doing." And she started yelling. He said, "Madam, I'll delete it in front of you." He deleted it. Yet next day, she put a post on the review thing, said that, hey guys, this doctor is a horrible doctor. He takes photographs of your private parts. He's written that. He takes photographs of your private parts, and his staff is also like that, and he is a rapist. You know, that kind of thing. So he came to me and he was very angry. I'll go to the police, I'll go to Just Dial, I'll do this. And as I was just discussing with Justice Tavde, so I told him, you calm down. The best way is just keep shut, do nothing. Because the more you write, the more reviews will come, more people will write, and eventually nothing is going to happen. If you go to Just Dial, the Just Dial will say that we can arrange a conference call. That's all. You talk to each other. Because she's also our client, just as you are our client. So they will do nothing. If you go to police, she might put some sexual allegations and so on. Okay?
Yes, thank
Right.
you so much.
So be very careful while taking photographs. In fact, he could have asked her to take photograph on her own camera, if at all.
Thank you, sir, for that advice. And I think our technical issue has been solved and we can go ahead with that. And it's a very important message that without permission, we should not be even sharing patients' photographs which we take intraoperatively. Yes, can we?
Yeah, I think, am I audible now?
Yes, yes, sir. Yes, sir. very-
I'm so sorry that these technical glitches took some important time. Anyway, we
Yeah.
start with that. And slides are also visible. So this is the definition of medical records. The one which I like the most and is comprehensive is that medical record is a clinical, scientific, administrative, educative, and legal document relating to the patient care in which are recorded sufficient data written, or now I would say entered in sequential manner to justify the diagnosis and therefore to justify your management and the end result. So this should be on logical and scientific basis. This was way back thought over as an important aspect of medical record in 1965. In that year, they have given several guidelines, some of which are still being followed. In short, the importance is communicate all that is documented. So whatever we are documenting needs to be communicated. It's no point in just taking the signatures. The things have to be completely communicated and seen to it that the patient has understood what we are writing, what we are consenting to, etc., and document whatever has been communicated. However, I would just say, this is my personal comment, it's easier said than done because we talk so many things, but maybe 5 to 7% is getting documented. So there is a big gap between the two. It's easier said, and with the huge mass of practice in this country, to get documentation of each and everything what we have spoken is really difficult. I would just enumerate the types of record. One is the record is anything which is a document, which has been, document is well defined in Indian Penal Code Section 2 in the definition clause. Patient related documents are something like registration paper, the OPD paper, indoor papers, X-rays, CMRIs, histopathology reports, operation theater notes and anesthesia notes, nursing register, and all of you are well aware with all these. Also critically important from medical legal point of view are the transfer notes and the discharge notes because it goes in somebody else's hands. So we have to be very careful about these. Certificates, I think it's a separate topic by itself, an important aspect of documentation of medical records. Identification of each patient is very important, and so on. Each page needs to have patient's name and ID, etc. Another type of record is CCTV footage, so it is graphic. Register of patients, OT and OT sterilization, staff appointments, etc. The third is the billing, financial aspects, bills, receipts, their PAN number, TAN numbers, the bank details, and so on and so forth. The separate system, I think this is important. Many times we overlook these things, is that various licenses of the hospital registration need to be filed together, and even the scanned copy should be preserved on your desktop then Shop Act license, biomedical waste disposal license or authorization, all the annual maintenance contracts that you are maintaining these equipments needs to be proved, and therefore the AMC's records has to be there. Fire NOC, MTP and PCP entity in appropriate cases, the dangerous drug licenses, the property records, all these are very much required. They should be very handy. Electronic and digital records are preferred these days and also encouraged by MCI or now the NMC. Police information cases, you preserve these documents forever, and records should be objective and not very lengthy, in the sense that it should not be very subjective. It should be objective to the point. We are not writing essays on these documents. There are two major types of record keeping. One is the manual, the older one, but the limitation is large storage area which is required. It occupies a lot of space, and every time we know that each square inch costs thousands of rupees. So the space constraints have to be taken into account. They are difficult to retrieve, but the paper documents have their own value also, particularly in the police cases or the medical legal cases, or where the dispute is likely, particularly in the court matters also. The documentation, the physical copy is important. Let this be complementary to the electronic or the soft records. Whereas the advantages, the same way the opposite side is advantages of the electronic system, that they're neat and tidy, data is easily stored, prescription is fully typed, so there is no confusion regarding what medicine is given, about the doctor's handwriting. I think there are thousands of jokes on that. The photos, X-rays, all images, reports are available at one click, and that easily a point you heard the last lecture. And irrespective of whatever the new systems are there of keeping your data absolutely confidential, there would be hackers for that also. So it is not 100% attack meditation, because it has been adequately covered in the previous talk. But for us, section 65A and B authorize us to keep the records in the electronic system. But please remember that this CD writing or whatever the whatever data writing we are using has to be tamper-proof, so that you should not be able to change, nobody should be able to change your documents afterwards. They should be serial. For the time being, we as medical legal experts would advise to have important documents, as I mentioned just a minute before, that some of the things need to be in the physical format also. And then we have to protect the cyber data against the leakages, have backups also, because there can be total loss of the data. So all of you must have experienced sometime in your life that how the data can be completely corrupt, or you can lose them easily. Now, attributes of a documentation medical records is take the Aadhaar copy of each patient. This is vitally important whenever you are treating the patient indoor as well as in the daycare center. So we should have a copy of the government photo ID, maybe PAN card also. So this is required for identification of the person. Make it a habit that we take and attach the Xerox copy. It's vitally important, especially in MTP cases, PCP entity cases, POXO cases, where you need to ascertain the person as well as the correct age. Also, people give the mobile number as contact detail, and you try to ring them up. See to it that the ring reaches that particular mobile, because I've seen time and again that they give sometimes some old number, some the husband gives the number of the wife, wife gives of the son. So it has to be of the person who is your patient. So check on that you give a call back and see to it that he receives the phone. Now, who is to write the clinical records? Only the registered doctors, nurses, and authorized persons. So these three categories, the registered doctors are those who are in charge of the patient, the nurses, and authorized persons. They must contain what a document should include, should contain the medication, the dosage, it administers. I recently had a medical legal case, I think 3 days back, where the pediatrician had written all the documents in the format something like this. Ampicillin at a dose of 100 milligram per kilogram divided in 2 doses. So this is not a dosage what we expect on indoor paper. We need to have milligram at a time into how many, at what frequency and how many days. So it should not be a theoretical dose. Then we have to document the allergies, relevant past and family history, counseling details, and this is preferred to be having it on CCTV coverage if possible. Answer should be clearly given. Another point comes, and this is often asked question, how long to preserve the documents? General answer would be 10 years. As far as OPD papers are concerned, there is no mention in MCI or NMC guidelines. But generally speaking, 3 years is sufficient. Whereas a ministry notification in 1968, that is a DGHS circular, has clearly mentioned that have the OPD records also for 5 years. That is for government hospitals. Why I'm saying 3 years? Because generally the period of limitation for the civil cases is 3 years, for consumer cases is 2 years. So I'm adding to that 1 grace year. So 3 to 5 years is more than enough. Whereas indoor papers should be preserved for 3 years according to MCI, but better to keep them for 7 to 10 years. But now with the cyber documentation, we can preserve it really for a long time without waste of any space. The British courts have held that you should keep the records for 6 years, indoor papers. Here is a hitch. For newborns, that is obstetric cases, the pediatric age group patients, that is the pediatricians, you have to preserve the documents up to 21 years of the child. The reason being, the child gets an opportunity, or he has the right to go in the courts for 3 years after attaining majority. So this becomes 18 plus 3, and therefore this is 21 years. So this is the maximum period of limitation for civil cases. There is no period of limitation for criminal cases. But if you have not got any intimation from police or criminal court or magistrate, you are not aware of that there is a criminal case which is coming. Somebody puts a case. This happens particularly in MTP cases, that there is a matrimonial dispute which comes up after 10, 12, 15, 20 years, and doctor is summoned that bring your papers. Here we have a safe way out, because the act says you have to keep the papers for 5 years. And now I don't have any document. So if you have not received any notice, you are safe to safe to say that I do not have records. Medical legal, keep them for 30 years. This is one of the notifications from government, though there is no clear-cut law on this. But then I would say, if you know that this is a medical legal case, police registered case, keep them forever, possibly till we die, till the doctor dies. Then the birth records at least for 21 years, but preferably for 30 years. And this is as per the hospital manual published in 2002 by Health Ministry, Government of India. No records is a primary negligence. So if somebody says in a defense that I don't have any records, there is a state consumer for say. Now PCB, this is now I'm sure all of you are aware that absolutely all the correct details, and there is no escapism from F forms as per the final judgment by Supreme Court on 3rd of May 2019. So F form that again highlights the importance of record keeping. This is a recapitulation. I mean, the same thing published by the government, and this is come in 2014. How long to keep the papers? Now, when you destroy the papers, this is an example that major hospitals, when they want to destroy, we have to put a notice one in vernacular and one in English language newspapers, saying that we intend to destroy the papers. Those interested in any case papers may write to the undersigned within 10 days, and you can hand over. For smaller hospitals, this is a bit difficult and a costly affair to publicize in newspapers. But that is a good way to destroy before you destroy the papers. Now, these are the characteristics of good document, that they should be, this is easier to remember. Everything starts with C. They should be clean, complete. So don't leave something halfway through, comprehensive, and not very elaborate and lengthy. should be correct and true. Notes of yesterday, that is 26th of November, should not be written after notes on 27th at 10:15. So this has happened time and again. They should be chronological. Then cancellation. Of course, we are writing and our mind changes. You want to change the drug, you want to change the dose, or you want to change the finding. It is allowed. Just put a simple scratch line and initial it and put a new one and put the date and time. Of course, date and time is mentioned and the left hand upper corner of the each paper also. Now, whose custody the case paper should be? It should be in the custody of the hospital or the doctor in charge. But then you are supposed to give the papers on written demand by the patient, that I will come to subsequently. But basically the hospital records or the documents are the property of the hospital. Only accepted short form should be used. For example, we have seen sometimes NCBD. So what is meant by NCBD? Nothing can be done. So this is not an accepted short form. Whereas WNL within normal limits will be taken as accepted short form in medical language. Consent is a very important document. It's a separate topic by itself. So I will not elaborate upon consent aspects at all. Medical records whose property is the property of the person who created it. That means the hospital and the doctors. Hospital has the right over the papers and patient-related documents, reports, etc., even if the patient has paid for it, but should provide a copy to the patient or his first-degree relative, or to the court or to the police on a written demand or a summons. Otherwise, don't give it to somebody else. It will be taken as a breach of confidentiality. So that should not occur. Also, one more important aspect has come out of practical experience, that particularly in will document or whenever the things are getting disputed, the one brother comes, he takes the papers, he gives in writing, he might have paid for it also. And the next brother comes, the third brother comes. So we have to take in writing that this is his responsibility to give the subsequent copies, because it has become a headache for one major hospital in Pune that 27 different copies ultimately they had to give. So that should not be, that should be their lookout. Insurance companies demand a full set of papers. It is construed as patient has consented for the same, as he is claiming for the reimbursement. So otherwise we should not give it to the third party. While handing over the document, this is a practical hint, number them serially. All papers should be numbered from 1 to 7. Take a sign of the receiver with the date and time and undertaking that he will not get any more copy. So this is one time only, and it will be his responsibility to give the copy in the other interested relatives for legal or other purposes. So it doesn't become your headache. While handing over, be careful to whom you are handing over. You should hand it over to the next of kin or the first degree relative or the patient himself or herself. Inform the person that this is his final copy and it is his responsibility, etc. Number all your papers. I think this is a repetition. Do not hand over the originals except to the courts and to the police if they need. Keep their written requisition as well as their official acknowledgement attached to the whole set of papers. Insurance, give a full set of Xerox copies. Family court matters, whom to give. If the matrimonial dispute is going on, the wife says, don't give it to the husband. And the husband says, I have got a right over this. So these are interesting questions. Take the consent of the patient before handing over the patient to somebody else. If papers are demanded after specified period, for example, 5 years in MTP or 2 years in PCPNDT, of course, you can just say that limitation period is over unless you have received a notice. Some examples of important documents are the discharge card. Very important. Do not give this responsibility only to the juniors. They can write everything or they can enter everything, but then unless you have checked it and signed, do not hand over, because this goes in patient's hands. Must have date of admission, date of discharge, time of admission, time of discharge, case number, summary of the whole happenings within the stay of the patient. Follow-up should be very clear. Clear instruction should be given. In case there is an emergency or urgency, where the patient should contact, whom to contact, all these details should be given. And just for a little mistake, courts have awarded severe damages in 2018 to the tune of 20 lakhs. Always keep the copy of the discharge note attached to the medical records. and write the advised investigation and follow up on the discharge card. This is particularly true if you advise CT, MRI, etc., and also in cases of retinopathy of prematurity, because if you don't write, it is taken as you had not intended to refer the patient to the ophthalmologist, and heaviest of compensation occur in those cases. Another important document is the prescription. As far as possible, should be neat. Now they are printed in majority of the cases. Good handwriting, or preferably should be typed, and drugs should be written in capital letters. Strength of the medicine should be written. Correct dose, clear instructions when to take it, how to take it, and full duration of treatment. Address and registration number is a must, and always give a follow-up date. The document should be clean, and this was a survey done in Calcutta that more than 6,000 OPD papers were screened, and what is the legibility of the prescriptions in only about 44.67%, and this is true in UK also. So there the legibility was just 20%. So similar studies on legibility, it does not exceed 65% of illegibility. So both can be avoided by electronic prescriptions. Prescription audits is also required what we are writing. Another important note is a transfer document. I think I'll take just 3 to 4 minutes more. Put the date and time of transfer, very important document. Write down the treatment summary and your assessment of patient condition. Some trained doctors to accompany while you are transferring the patient from your hospital. A format is prepared by us. In case you require, we'll send you a copy and you can use them. Whether to give a full set of paper, this is something which I did not comprehend well, because in a recent judgment, Delhi's State Commission has severely given a compensation to, in one case, that why you did not send a full set of papers and just send a transfer note with adequate details. So what we should be writing, that further details can be provided on request, something like that. General suggestions are: write the advised investigation on prescription also. Always give the next appointment. Keep the addresses of all your staff for 10 years. Don't overthink of the patient's pocket. Seek help before submitting any documents to anybody. So take the help of your medical legal cell. One of the examples, as in seen in this particular case in a cataract surgery, that there was no improvement following the cataract. Patient approves the consumer forum, but it was clearly mentioned in the history notes as well in the consent that there may not be the achievement of vision because the child from childhood, one of the eyes was amblyopic, and therefore, because this was shown as a document, there was a complete exoneration against the claim. So similar documents have important history points are needed to be written. Chronic medication should be written. Important diseases in the past should be written. So this is how this particular paper mentioned that मला माझ्या डोळ्याचे मोतीबिंदूचे ऑपरेशन झाल्यामुळे त्यात पूर्ण सुधारणा येईल असं नाही, त्याची कल्पना डॉक्टरनी मला दिली आहे. So it is in his vernacular language, and this was clearly mentioned before surgery. Another some important documents which are overlooked many a times are the fumigation record, autoclaving of the instruments, and that turning of the details of the autoclave label, that also should be there. Any processes, lens or stents you put, you need to paste the label of that manufacturer onto the case paper. I mean, that is a requirement for every insurance case, but also true that even if insurance claim is not there from the patient's side, preserve it and attach them to the case papers, just as we keep the blood bottle labels attached to the paper. Denial documentation is important, more important sometimes than even the consent, that you are given a particular advice, patient does not obey it or says that he's not going to do the surgery, not going to come up, he's not going to do this particular treatment. Document it well, and the documentation should be as in good details as a consent. Documentation of the uncooperative and abusive patients and patient's behavior also needs to be done. Documentation of the absconding patient. They can sometimes snatch away your documents also. Report it to the police immediately. However, I wonder sometimes, to prepare so many documents and maintain well with all these details, are we going to lose the sight of the main medical attention? And see, in my own case on 23rd of October, I fell in USA, had 6 stitches under the chin, and see the documents were 9, whereas the delay was for 5 hours. I will show you these documents when I open my video. So that should not happen. I think our system is good. We give emergency care and then simultaneously we go for documents. So we should not lose the sight of our important clinical work. Certificates, I think I will not dwell upon this. And only thing you can charge for all the certificates except death certificate. And they should be, of course, preserve the copy and never issue the second copy of the birth and death certificates. That has terrible consequences. Only one time given copy. If they want any change or modification, they should go to the respective legal authorities. Special attention of documentation needs to be done for moribund patients, patients developing complications of a serious diagnosis, drugs, diseases, procedures, anesthesia. Certain serious turn in case of transfer or referral of a patient, accident, suicide, suspected homicide. Of course, they need to be informed to the police in time. Consent and certificates are important documents. All important registers like MTP and PCP entity and any conflict, major, minor, or even suspicious, keep the records for a much longer time. And in case there is an indemnity insurance, and I'm sure you should not be practicing without indemnity insurance, inform your insurer immediately. Thank you so much for the patient listening. I'm so sorry for the technical glitches, and I can make my video open now. And thank you very much the support team that they could rectify this technical problem fairly in time. Thank you so much. And thank you for giving me an opportunity to share my views.
Thank you. Thank you, Dr. Jayant Naurange, for a fantastic narration and the requirements about the documentation. But only thing is that it is so scary that
I know
people should not start thinking that it is better to not practice or keep extra persons to have this documentation. Thank you.
Sir,
Thank you very much.
I can just share.
Hemant,
Yeah, this is the set
Dr.
of documents I
Naurange,
received.
thank you for joining us. We have time only for one question. So one
Yeah.
question from the audience.
Does patient has right to indoor newspaper while he is admitted? That is because we face a lot of this situation where suppose a doctor is
Okay,
admitted.
I will just repeat it so that, Dr. Jayant, the question was, does
Yes.
the patient have the right to review the treatment papers while he is under your care? Can you just answer that for the benefit of the audience?
He has all the rights. I would say he can demand the Xerox of his papers while he is getting treatment also, and he has the right to show it to some other doctor. So we have to cooperate, and we can give parcel set of papers on a written demand from them.
Thank you very much, sir. And I would request
Thank
the
you, ma'am.
audience, if you have any further questions, please write them down on a piece of paper and pass them forward. At the end, we will try to answer them. Thank you, Dr. Jayant, and over to you.
Thank you, ma'am.
Yeah.
Thank you, sir. Now I'll request our senior most Bhishma Pitama of our AMC and President FAMC, Federation of Association of Medical Consultants, Dr. Lalit Kapoor, sir, to come forward and introduce Justice Tavde, our chief guest today. Yeah, once you introduce, then we'll have the lighting of the lamp.
Yes.
First introduce, sir.
Is it still morning? Yeah, it's still morning, I think. Good morning, friends, and welcome to this Mlcon and Famcicon, very important meeting with such illustrious speakers. And of course, the icing on the cake is about to happen, where we have Honorable Justice S.P. Tavde to address us. It is indeed my proud privilege to present to you a person as eminent as Honorable Justice Surendra Pandarinath Tavde, currently President of the Maharashtra State Consumer Dispute Redressal Commission. The job of a judge is much more difficult than we imagine. I realized this when sometime back, two of my friends came to me after a fight. They had some quarrel. And they had allegations and counter allegations from both the sides. These friends, he said, he did this, and first he told me, first he insulted me. And I was asked to give a verdict as to who was right. So that is the time I realized judge's job is difficult, very difficult. We think our job is difficult. They're doing a very difficult job and they're doing it well. Justice Tavde is doing just this from morning to evening, fulfilling his obligation of delivering justice with fairness and equity. We are truly grateful to Honorable Justice Tavde for accepting our invitation and sparing the only free day he gets to be amongst us and enlighten us on the various aspects of CPA in relation to medical professionals. Thank you very much, sir. Justice S.P. Tavde was born in Ratnagiri and belongs to a family of lawyers and judicial officers. He has practiced at the City Civil, Sessions Court, Metropolitan Court. He worked his way up as Judicial Magistrate First Class, JMFC. He was promoted as Additional District Judge in December 2007. He served as Principal District Judge at Osmanabad and Sangli, after which he served as Joint Secretary Law and Judiciary Department, Mumbai, followed by Registrar General at the Bombay High Court. He took a keen interest in the welfare of judges of the district judiciary and rose to be the president of the Maharashtra State Judges Association. He was confirmed as permanent judge in December 2019, a position he held up to June 2021. And here he is now as president, Maharashtra State Consumer Dispute Redressal Commission, a position he took up in May 2022. It is my great pleasure to extend to you, sir, a hearty welcome and request you to address our members. Thank you.
I'll request our President, Dr. Nilima, to escort Justice Tavde for the lighting of the lamp. Dr. Lalit Kapoor, sir, Dr. Kishore Adintia, who is the Secretary for Famcicon, also to join.
Kratunda Mahakaya Surya Koti Samaprabha Nirvignam Kuru Me Deva Sarvakaryeshu Sarvada Vakratunda Mahakaya Kratunda Mahakaya Surya Koti Samaprabha Nirvignam Kuru Me Deva Sarvakaryeshu Sarvada Vakratunda Mahakaya Kratunda Mahakaya.
Thank you so much, dignitaries, for inaugurating our program. And now, can I request everyone to please, the dignitaries to remain forward, and we will now have felicitation of our chief guest for today. Can we request Dr. G.B. Kulkarni and Dr. Niranjan to come forward? We would like to felicitate Justice Tavde. Sir, could you please come forward? Our President, Secretary, Dr. Nilima and Kapoor, sir. We request Dr. G.B. Kulkarni to felicitate sir with a shawl, and Dr. Niranjan Agarwal to please felicitate him with a shrifal. Can we have a big round of applause, audience? And may I request our President and Secretary to please felicitate Justice Taude, and let's all give him a big round of applause for the time and effort he has taken to be here right from the morning. Thank you, sir. And we would now request sir to please come forward to give his speech. PPT.
Close it here also.
Very good morning all. Dr. Lalit Kapoor and his team, all doctors present here. My lawyer friends are here. I thank to Dr. Kapoor. He said that job of judge is very difficult. Somebody has acknowledged our pains also. Consumer Protection Act. The movement started from Pune, and ultimately the Act of 1986 came into force. The said Act was implemented for more than 30 years, and then the government felt that there is need to improve it for one reason or the other reason. And ultimately in the year 2019, the Act was amended, and now we are implementing since December 2020. So I'll directly come to new Act which came into force in 2019. The digital age has ushered in a new era of commerce and digital branding, as well as new set of consumer expectation. Digitalization has provided many access, a large variety of choices, convenient payment mechanism, improved services and shopping as per the convenience of a consumer. However, there are also associated challenges related to Consumer Protection Act. And I think that was the reason where the Act was amended and new provisions are included in the Act. The Consumer Protection Act 19 is a law to protect the interest of consumer. The Act provides safety to consumers regarding defective products, dissatisfactory services, and unfair trade practices. The basic aim of a Consumer Act is to save the rights of consumers by establishing authorities for timely and effective administration and settlement of their disputes. The consumers have the right to information on various aspects of goods and services. This could be information about quantity, quality, purity, potency, price, and standard of goods and services they avail. To be protected from hazardous goods and services, right to protection against goods and services that they can be dangerous to life and property. To be protected from unfair and restrictive trade practice, consumers have right to access a variety of goods and services at competitive prices. Consumers should have a right to redressal. Therefore, the forums are created in the Act. Now the definition of consumer. There are 3-4 definitions in fact, the person, then consumer, and who is a complainant. The 3 are inclusive of all. The consumer definition of consumer is, as per the Act, is a person called consumer who avails the services and goods services and buys any goods for self-use. They're very important, self-use. Worth to mention that if a person buys any goods or avails any service for resale or commercial purpose, he or she is not considered as a consumer. This definition covers all types of transactions, offline, online, through tele, shopping, direct selling, and multi-level marketing. The Consumer Act has first time created an authority. It is on a national level. It is called as Central Consumer Protection Authority. The Act proposes the establishment of Central Consumer Protection Authority, CCPA, as a regulatory authority. CCPA will protect, promote, and enforce right of consumers and regulate cases related to unfair trade practice, misleading advertisement. This first time came in the Act, and violation of consumers' right. The CCPA will have right to take summatory actions, recall products, to ask the manufacturer to recall the product, order reimbursement of price of goods and services, cancel licenses, impose penalties, and file class action suit rather. CCPA will have an investigation wing. It can also inquire and investigate the malpractices played by the houses, manufacturers, and conduct independent inquiry and investigation into the consumer law violators. The Act has the provision of establishment of consumer dispute redressal commissions at district level, at state level, the State Consumer Dispute Redressal Center, and at national level, is National Consumer Redressal Commission. Then the new act provides flexibility to consumer to file complaints with jurisdictional consumer forum located at place of residence or workplace of a consumer. This is a problem created for a medicos because most of the doctors in Bombay or the hospitals in Bombay treat the patient throughout the country. And if anything goes wrong, then the complaint would be filed by the person who is coming to Bombay for treatment, and then you'll have to go to the place where he resides. So this is a new amendment in the Act. Earlier, the place of a trader or place of a service provider was the place for filing complaint. That has been changed, and that is a drastic change affecting the medicos as well. Thank you, sir. This is unlike earlier condition where consumer had to file complaint at a place of purchase or where the seller has its office or shop. That has been changed now. The new Act also contains enabling provision for consumer to file complaint electronically and for hearing and or examining parties through video conferencing. The Act introduced the concept of product liability. It was not in earlier Act or old Act. A manufacturer or product service provider or product seller will now be responsible to compensate for injury or damage caused by the defective product or deficiency in service. This provision brings within its scope the product manufacturer, product service provider, product seller for any claim for compensation. The term product seller would also include e-commerce platform. The CCPA may impose penalty on a manufacturer or an endorser for a false and misleading advertisement. CCPA may also sentence them to imprisonment also. This provision has come recently in the Act. Earlier, there was no authority, so there was no question of granting sentencing any manufacturer or defaulter. New Act provides for mediation as an alternate dispute resolution mechanism. For mediation, there will be a strict timeline fixed in the rules. As per the recent notified rules, a complaint will be referred by Consumer Commission or for mediation, where scope for early settlement exists and parties agrees to it. Mediation will be held in the mediation cell to be established under the aegis of Consumer Commission. There will be no appeal against the settlement through the mediation. But while making this provision, the cases of medical negligence are kept out of this mediation. I don't know why that was the why it was kept out of the mediation, because ultimately the consumer come for the compensation. If he go for a mediation, he may get more compensation also, or he can settle his dispute at an earliest point of time. That has to be now requested by the association to get the medical cases in the mediation. A new act has armed the authorities to take action against unfair trade practice too. The act introduces a broad definition of unfair trade practice, which also includes sharing of personal information given by the consumer in confidence, unless such a disclosure is made in accordance with the provisions of any other law. The Central Consumer Protection Council is also created by the new act. This Consumers Protection Act empowers the central government to establish a Central Consumer Protection Council. It will act as an advisory body on consumer issues. As per the notification, Central Consumer Protection Council rules, the Central Consumer Protection Council would be headed by Union Minister of Consumer Affairs, Food and Public Distribution, with Minister of State as a Vice Chairman and 34 members of a different fields. The council has also 3 years tenure, will have a minister in charge of consumer affairs from 2 states from each region, north, south, east and west, and even northeast region. There is also a provision for having working groups from amongst the members of specific tasks. The act is also applicable to all product and services until and unless product or service is especially debarred out of the scope of this act by the central government. Empowering the consumers. The new act will empower consumers and help them in protecting their rights through its various rules and provisions. The act will help in safeguarding the consumer interests and rights. Consumer-driven business such as retail, e-commerce would need to have robust policies dealing with consumer redressal mechanism at plates itself. A new act will also push consumer-driven businesses to take extra precautions against the unfair trade practices and unethical business practices. In earlier act did not specifically include e-commerce transaction, and this lacuna has been addressed by this new act. E-commerce has been witnessing tremendous growth in recent times. Indian e-commerce market is expected to grow $200 billion by 2026. The act also enables regulation to be notified on e-commerce and direct selling with a focus on protection of interest of consumer. This would involve rules for the prevention of unfair trade practices by email e-commerce platform also. As per the notified rules, every e-commerce entity is required to provide information relating to return, refund, exchange, warranty and guarantee, delivery and shipment, modes of payment, grievances, redressal mechanism, payment method, the security of payment method, charge back option, etc., including country of origin, which are necessary for enabling the consumer to make an informed decision at pre-purchase stage on its platform. The e-commerce platform will have to acknowledge the receipt of any consumer complaint within 24 hours, 48 hours, and redress the complaint within 1 month from the date of receipt of the complaint. This will bring e-commerce companies under the ambit of structured consumer redressal mechanism. E-commerce entities are also commerce entities that do not comply with the above provision will face the penal action. Time-bound redressal. A large number of pending consumer complaints in consumer court have been common across the country. The new act is simplifying the resolution process, can help solve the consumer grievances speedily. The timely limit is given 90 days for general complaints and 150 days for complaints having the investigation or special or expert's opinion for that. New Act fixes liability on endorsers, considering that there have been numerous instances in recent past where consumers have fallen prey to unfair trade practices under the influence of celebrities acting as a brand ambassadors. This will make all stakeholders, brands, agencies, celebrities, influencers, and e-commerce players a lot more responsible. A new act would force the endorser to take an onus and exercise due diligence to verify the veracity of claim made in the advertisement to refute the liability and claim. Upholding the consumer's interest. For the first time, there will be an exclusive law dealing with the product liability. Product liability provision will deter the manufacturers and service providers from delivering defective products and defective services. The new legislation empowers National Consumer Redressal Commission as well as State Commission to declare null and void any terms of a contract while purchasing a product. This will go a long way in protecting consumers who often are subject to contract condition and that favors the seller or the manufacturer. The provision of mediation will make process of dispute adjudication simpler and quicker. This will provide a better mechanism to dispose of consumer complaints in a speedy manner and will help in disposal of large number of pending cases in consumer court across the nation. The question was given to me by Dr. Kapoor. What is the period of pendency in the consumer court? At present, the scenario is very sad. The cases are pending for more than 5 years. Some cases are also pending for more than 10 years also. In my court, the appeals are since 2000 are pending. The data is that there are around 18,000 matters are pending in the State Commission, and there is no appointment of a member since last 1 year. So the courts are vacant, therefore the pendency is increasing, and probably this mediation may act because parties generally don't go for mediation. Now we are compelling them to go for mediation to settle their dispute. So we hope that this mechanism may help us to reduce the pendency. The new act would ease the overall process of consumer grievances redressal and dispute resolution process. This will help reduce inconvenience and harassment of a consumer. The enhanced pecuniary jurisdiction and the provisions providing statutory recognition to the mediation process enabling filing of complaint from any jurisdiction, and for hearing parties to the video conferencing will increase the accessibility to the judicial forum and afford crucial protection in terms when international e-commerce giants are expanding their business in India. Apart from now, some concerns are there. Apart from Consumer Protection Act 2019, the Ministry of Consumer Affairs will prepare a code of conduct for advertisers and agencies, a move designed to curb unfair trade practices and misleading advertisement and their claims. The planned code will detail penalty for the advertisers and their agencies and publishers if misleading advertisement and false claims are found to be true or correct. The existing vacancies, I just made a reference. Existing vacancies at a district commission level would undermine the effective implementation of new act. As per the proposed rules for e-commerce business, companies are not allowed to manipulate the price of goods and services offered on their platform to gain unreasonable profit and discriminate between consumers of a same class or make any arbitrary classification of consumers affecting their rights under the Act. The clause of manipulation of price by e-commerce companies appears irrelevant, as sometimes e-commerce companies would want to reduce the price to enhance sales volume. For a country with a market size of around $25 billion, the guidelines should have taken a deeper view of an e-consumer ecosystem covering all prevailing business models between consumers, marketplaces, and the sellers. Now, frequently asked questions. In order to protect the consumers from exploitation or to save them from adulterated and substandard goods and deficient service, the Consumer Protection Act came into force in 86. It was replaced by 2019, Act of 2019. The new Act has widened the definition of consumer. The Act proposes establishment of Central Consumer Protection Authority as a regulatory authority. The new Act provides flexibility to consumer to file complaint with jurisdictional consumer forum located at a place of their residence or workplace. The Act has introduced the concept of product liability. The new Act provides for mediation as an alternate dispute resolution mechanism. For mediation, there will be a restrict timeline fixed by the rules. New Act has armed the authorities to take action against unfair trade practices too. This Act is applicable to all product and services until and unless any product or service is especially debarred out of the scope of this Act by the central government. The basic aim of Consumer Protection Act 2019 to save rights of consumers by establishing authorities for timely and effective administration of settlement of dispute. Now I'll come to our topic. It is slightly, my paper is slightly bigger, but I'll try to cut it short. It is important to know what constitutes medical negligence. A doctor owes certain duties to the patient who consult him for illness. A deficiency in this duty result in negligence. A basic knowledge of how medical negligence is adjudicated in various judicial courts of India will help a doctor to practice his profession without undue worry about facing litigation for alleged medical negligence. Lately, Indian society is experiencing a growing awareness regarding patients' rights. This trend is clearly visible from recent spurt in litigation concerning medical profession or establishment liability, claiming redressal for these suffering caused due to medical negligence, vitiated consent, breach of confidentiality arising out of doctor-patient relationship, the patient-centered initiative of rights protection is required to be appreciated in economics content of a rapid decline of state spending and massive private investment in the sphere of health care system, and Indian Supreme Court's painstaking effort to constitutionalize the right to health as a fundamental right. As of now, adjudicating process with regard to medical professional liability, be it in a consumer forum or a regular courts or criminal courts, considers common law principles relating to negligence, vitiated consent, and breach of confidentiality. However, it is equally essential to note that protection of patients' right shall not be at the cost of professional integrity and autonomy. There is definitely a need for striking a delicate balance, otherwise consequences would be very disastrous. In the context of obtaining processes, there is deserving need for a twofold approach. On one hand, a desirable direction points towards the identification of minimum reasonable standard in light of the social, economical, and cultural context that would facilitate to adjudicators to decide issue of a professional liability on an objective basis. On the other hand, such identification enables the medical professionals to internalize such standard in their day-to-day discharge of professional duties, which would help hopefully prevent a large extent the scenario of protection of patients' right in a litigative atmosphere. In the long run, the present adversarial placement of doctor and patient would undergo a transformation to the advantage of patient, doctor, and society at large. Now, who can file a complaint? I already said that consumer or any consumer or any organized consumer association, that is voluntary consumer association registered under Companies Act or any other law for a timing in force, whether consumer is member of such association or not, or central government or the state government. Who is a consumer? A consumer is a person who hires or avails any service for consideration that has been paid, promised, partly paid, partly promised, or under any system of deferred payment, and includes any beneficiary of such services other than person hires or avails the services for consideration paid, promised, or under any system of deferred payment. When such services are availed of with approval of a first mentioned person, the definition is wide enough to include patient who merely promise to pay. A complaint is an allegation in writing made by complainant, that is consumer, that he or she has suffered loss or damage as a result of any deficiency of service. What is mean by deficiency service? Deficiency service means any fault, imperfection, shortcoming, or inadequacy in quality, nature, manner of performance that is required to be maintained by or under any law for the timing in force has been undertaken to be performed by a person in pursuance of contract or otherwise in relation to any service. The complaint is to be filed before district forum if value of services and compensation claimed is less than 50 lakhs. before the State Commission if value of goods and services and compensation claimed does not exceed more than 2 crores. In National Commission, if value of goods or services and the compensation exceeds more than 2 crores. There is minimum fee for filing complaint before the District Commission. Up to 5 lakhs, there is no fee prescribed. An appeal against the decision of District Forum can be filed before the State Commission. Appeal will then go from State Commission to National Commission and from National Commission to the Supreme Court. The time limit within which the appeal to be filed is 30 days from the date of decision in all cases. The powers of a consumer forums or commissions. The forums or commissions have variety of powers. They are summoning and enforcing the attendance of any defendant, witness, and examining witness under the oath, discovery and production of document and other material, object producible as a evidence, reception of evidence on affidavit, summoning any person, expert person for adducing evidence or his testimony, the requisitioning of report of concern analysis or test from the appropriate laboratory or from any other relevant source, issuing of commission for examination of witnesses or any other matter which may be prescribed. The process before the competent forum will be set in motion in following manner. When complainant files written complaint, the forum, after admitting the complaint, sends a written notice to the opposite party, asking him to file a written version within 45 days. Earlier it was 30 days. Now it is 45 days. Thereafter, subsequent to proper scrutiny, the forum would ask the either filing of an affidavit or production of evidence in form of interrogatories, expert evidence, medical literature, and judicial decisions. Then medical negligence deficient. The negligence is simply failure to exercise due care. The 3 ingredients of negligence are very important. Defendant owes duty of a care to plaintiff. Defendant has breached this duty of care and plaintiff has suffered an injury due to the breach. Medical negligence is no different. It is only that in medical negligence case, most often doctor is a defendant. It is well known that doctor owes duty of a care to his patient. This duty can be either a contractual duty or duty arising out of tort law. In some cases, however, though doctor-patient relationship is not established, the courts have imposed duty upon the doctor. In other words, the Supreme Court says every doctor at governmental hospital or elsewhere has a professional obligation to extend his services with due expertise for protecting life. These cases are, however, clearly restricted to situations where there is danger to life of the person. Impliedly, therefore, in other circumstances, doctor does not owe a duty. A duty owed by doctor towards his patient, in other words, of the Supreme Court, is that bring to his task a reasonable degree of skill and knowledge, and to exercise a reasonable degree of care. The doctor, in other words, does not have to adhere to highest or sink to lowest degree of care and competence in light of the circumstances. A doctor, therefore, does not have to ensure that every patient who comes to him is cured. He has only ensure that he confirms a reasonable degree of care and competence. Now, reasonable degree of care. Reasonable degree of care and skill means that degree of care and competence that an ordinary competent member of a profession who possesses to have those skills would have exercised in the circumstances in question. At this stage, it may be necessary to note the distinction between standard of care and degree of care. Standard of care is a constant and remains the same in all cases. It is the requirement that the conduct of a doctor be reasonable and need not necessarily conform to the highest degree of care or lowest degree of care possible. The degree of care is very variable and depends on the circumstances. It is used to refer what actually amounts to reasonableness is in given situation. Thus, though the same standard of care is expected from generalist and a specialist, the degree of care would be different. In other words, both are expected to take reasonable care, but what amounts to reasonable care with regard to the specialist differ from what amount of reasonable care and reasonable care is standard for the generalist. In fact, the law expects specialists to exercise ordinary skill of his specialty and not of any ordinary doctor. Though court have accepted the need to impose a higher degree of duty on a specialist, they have to refuse to lower it in case of novice. Another question that arises with regard to the knowledge that is expected from the doctor. Should it include latest development in the field, hence require constant updating, or is it enough to follow what has been traditionally followed? It has been recognized by the court that what amounts to reasonableness changes with the time. The standard, as stated clearly herein above, requires that the doctor possesses reasonable knowledge. Hence, we can conclude that doctor has to constantly update his knowledge to meet standard expected of him. Furthermore, since only reasonable knowledge is required, it may not be necessary for him to be aware of all developments that have taken place. We have until now examined duty of doctor insofar as treating a patient is concerned, or diagnosing the ailment. Doctors are, however, imposed with a duty to take consent of a person or patient before performing act like surgical operation or procedure. In some cases, treatment as well. To summarize, an act that requires contact with patient has to be consented by the patient, has to be with the consent of the patient. A duty of care is imposed on a doctor in taking patient's consent. Naturally, a question arises as to what is the duty of care. As per the judicial pronouncement, this duty is to disclose all such information as would be relevant and necessary for the patient to make a decision. Therefore, a duty does not extend to disclosing all possible information in this regard. Furthermore, duty does not extend to warning a patient of all normal attendant risks of an operation. The standard of care required of a doctor while obtaining consent is again that of a reasonable doctor, as in other cases. Liability of a doctor arises not only when the patient has suffered any injury, but when injury has resulted due to the conduct of a doctor, which has fallen below that of reasonable care. In other words, doctor is not liable for every injury suffered by a patient. He is liable for only those that are consequence of breach of his duty. Hence, once existence of duty has been established, the plaintiff must still prove breach of duty and the causation. In case there is a breach or breach did not cause damage, the doctor will not be liable. In order to show breach of duty, the burden is on plaintiff would be to first show that what considered as a reasonable under those circumstances, and then that conduct of a doctor was below this degree. It must be noted that it is not sufficient to prove breach, merely to show that there exists body of opinion which goes against practice and conduct of a doctor. With regard to the causation, the court has held that it must be shown that all possible reason for the injury, the breach of duty of a doctor was most probable cause. It is not sufficient to show that breach of duty is merely one of the probable causes. Hence, if possible causes of an injury are the negligence of third party, an accident, or breach of duty care of a doctor, then it must be established that the breach of duty of a care of a doctor was the most probable cause of injury to discharge the burden of proof on a plaintiff. Normally, liability arises only when plaintiff is able to discharge burden on him of proving the negligence. However, in some cases, like swab left over the abdomen of a patient and leg amputated instead of being put in cast to treat the fracture, the principle of res ipsa loquitur, means things speaks for itself, might come into play. The following are necessary conditions for this principle: complete control rests with the doctor. It is the general experience of mankind that accident in question does not happen without negligence. This principle is often misunderstood as a rule of evidence, which is not. It is a principle in law of tort. When this principle is applied, the burden is on the doctor or defendant to explain how incident could have occurred without negligence. In absence of any such explanation, liability of a doctor arises. Normally, a doctor is held liable for his acts other than cases of vicarious liability. However, in some cases, doctor can be held liable for acts of another person which injures the patient. The need for such liability may arise when person committing the act may not owe duty of care at all to patient, or that in committing act he has not breached any duty. A typical example of a case where such a situation may arise in a case of surgery. If junior doctor involved as a part of team, then his duty as far as the exercise of specialist skill is concerned is to seek advice or help of a senior doctor. He will have discharged his duty once he does this and will not be liable even if he actually commits act which causes injury. In such case, it is duty of a senior doctor to have advised him properly. If he did not do so, then he would be the one responsible for the injury caused to patient, though he did not commit it himself. A doctor is not necessarily liable in all cases where patient has suffered an injury. This may either be due to the fact that he has valid defense or that he has not breached duty of care. Error of judgment can either be a mere error of judgment or error of judgment due to the negligence. Only in the case of former, it has been recognized by courts as not being breach of duty of a care. It can be described as the recognition in law of human fallibility in all spheres of life. A mere error of judgment occurs when doctor makes a decision and turns out to be wrong. It is a situation in which only retrospect can we all say there was an error. At the time when the decision was made, it did not seem wrong. If, however, due to consideration of all factors was not taken, then it would amount to an error of a judgment due to negligence. And there are many cases which I will not consider, but what standard of care is to be required. It is now settled principle of law that medical practitioner will bring to his task a reasonable degree of skill and knowledge and must exercise a reasonable degree of care. Neither the very highest nor the very lowest degree of care and competence judged in the light of circumstances in each case is what the law requires. Judged from this yardstick, post-operative infection or shortening of leg was not due to any negligence or deficiency in service on the part of the opposite party, that is doctor. Deficiency in service thus cannot be fastened on the opposite party. In one case, that led a visual impairment as a side effect, the following observations were made by the court. The literature with regard to Larigo clearly mentioned that the side effect of this medicine, if taken for long duration, can affect eyesight, but this is not a fact in this case. Besides, there is no expert evidence on record to show that use of this medicine cause damage to patient's eyesight. Even for the argument's sake, if it is accepted that this medicine caused damage to the patient's eyesight, if respondent doctor is one who has advised his patient to use this medicine after an examination in which he found the patient to be suffered from malaria, in that case as well, doctor respondent cannot be held guilty for negligence or deficient in service. However, as stated above, in this case, the medicine has been used by the patient in low doses for a few days, and there is no expert evidence to show that use of medicine has affected his eyesight. Therefore, complainant or the patient has failed to prove that respondent was negligent and deficient in his duty while giving treatment. Proof of medical negligence. It has been held in different judgment of National Commission and by Honorable Supreme Court that charge of professional negligence against a doctor stood on a different footing from the charge of negligence against the driver of a vehicle. The burden of a proof is correspondingly greater on the person who alleges negligence against the doctor. It is known fact that even with a doctor with the best skill, things sometimes go wrong during the treatment, medical treatment, or in a surgery. Doctor is not to be held negligent simply because something went wrong. It is an admitted fact that the complainant's eyesight was not restored after operation was concluded by doctor, but on this ground alone, doctor cannot be held negligent, because even after adopting all necessary precautions and care, the result of operation may not be satisfactory since it depends on various other factors. The contention of doctor was that the patient was suffering from diabetes and blood pressure, and in many such cases, eyesight is not restored after operation. However carefully it is done. In this case, there is nothing on record to show that something went wrong due to an act of doctor. There is no evidence come on record to conclude that the doctor fell below standard of reasonably competent practitioner in their field, so much so that their conduct might be deserving a censure. The doctor cannot be liable for negligence because someone else of better skill or knowledge would have prescribed a different method of operation in different way. The evidence suggests that the doctor has performed the operation and acted in accordance with the practice regularly accepted and adopted by him in his hospital, and several patients are regularly treated for their eye problems. So there are also many cases where the need for expert medical evidence is required in the complaints. Commission cannot constitute itself into expert body and contradict the statement of doctors unless there is something contrary on record by way of expert opinion, or there is any medical thesis on which reliance could be placed. In one case, there was a false allegation of urinary stone not being removed as shown by a shadow in the X-ray. The burden of proving negligent act or wrong diagnosis was on the complainant and the appeal was dismissed. In another case, alleged medical negligence as no expert evidence was produced. The case was discussed below is not a case of apparent negligence on the part of the surgeon in conducting operation, but about quality of plate used for fixing bone. In the said case, the complainant has not produced any expert witness to prove that there is any fault in the performance of operation. The fixation of bone by using plates is one of the recognized mode of treatment in the case of fracture of bones. If opposite party has adopted the aforesaid method, though subsequently the plate broke, the opposite party has adopted the opposite method, though subsequently plate broke, negligence cannot be attributed to doctor. This is not a case where wounds of an operation were infected or any other complications arose. Breaking the plates approximately 6 months after it was placed cannot be attributed towards the negligent act of a doctor in performing the operation. There are many cases wherein such type of observations were made by the Supreme Court, even in the National Commission also. But I'll point out one more. The courts and consumer fora are not expert in medical science and must not substitute their own views over that of specialist. It is true that the medical profession has to an extent become commercialized, and there are many doctors who depart from their oath for their selfish aim for making money. However, the entire medical fraternity cannot be blamed or branded as lacking in integrity or competence just because some of bad apples. It may be remembered that sometimes, despite their best effort, the treatment of a doctor fails. For instance, sometimes, despite the best efforts of surgeon, a patient dies. That doesn't mean that doctor or the surgeon must be held guilty of medical negligence unless there is duty. There is some strong evidence to suggest that he is guilty. On the particular fact, on the facts of the particular case, we are of the opinion that the doctor was not guilty. There is a latest judgment of Justice landmark judgment, not latest, landmark judgment of Justice Markandeya Karju, and he has given some guidelines in that judgment. On one hand, it raised the speculative nature of our judicial adjudication of medical negligence liability, and on the other hand, it is abundantly clarifies that unless there is prima facie evidence indicating medical negligence, notice either to doctor or hospital cannot be issued. At the same time, a core essence of the judgment makes it very clear that there cannot be an assumption that doctors cannot be negligent while rendering the care and treatment. I think this timely intervention should be disseminated at the popular level so that the mandated Supreme Court's prescription will be observed in more practice than the breach. So we'll have to learn the many judgments of Supreme Court wherein the negligence aspect is widely considered, and some principles are laid down by the Supreme Court, which will be guiding force for us to decide in how to behave, how to practice in the while treating the patients. Dr. Kapoor has given me 4 or 5 questions. So I'll consider that those questions. He asked me what is the average age of judgment in district and state forum. There are some district forums who are very fast in disposal, but at a state commission the period is very average time of judgment is very lengthy. Rather there is a delay in disposing cases, mostly because of vacancies, and some lawyers are there. I don't want to offend them, but sometimes the lawyers file number of documents and papers to decide. The object of consumer forum was to decide the complaint on the basis of affirmation. They need not go into the probe or to decide what is the whether there is a fraud, whether there is a proper consent was obtained or not. Once the consent paper is taken on record, as far as the medical case is concerned, if doctor files a consent of the patient for removal from the ICU to some other ward or ward to ICU, that consent should be seen on the paper which is produced on record. But sometimes the patient denies his signature on a consent form. Then we are not supposed to decide that aspect, because then needs the evidence whether he has signed it or whether that document is genuine. The document is not genuine, but we cannot go into it. But sometimes we are required to decide that also. Therefore, sometimes there is a delay. The second question is, under CPA Act, patient can complain from his place of residence, which may be far removed from the place of event took place. It is true. Now there is a specific provision where the complaint can be filed by the consumer from his place of residence or place of work. So this is affected the medical field very adversely. Current provisions for preferring appeal against the judgment. There is a provisions of appeal. The appeal from the order of a district commission can be filed before a state commission within 30 days from the date of order or date of receipt of order by the consumer or the other party. And similar is the position for the national commission, 30 days from the date of receipt of order of a state commission. Can two parties reach amicable settlement before litigation and register consent terms in forum, giving it a legitimacy? It can be done, but they cannot come through the process of mediation, because mediation is completely barred. These the medical negligence cases are barred from placing before the mediation. But if complaint is filed and there is a settlement arrived at between the parties, it can be filed before the forum or commission. Doctor feel condonation of delay in filing complaints as per the statute of limitation is granted too easily. It is true in some cases that those are granted, but the essence of granting condonation is that there must be a reasonable and fair reason to condone the delay. Sometimes the patient may say that he was undergoing treatment and he was under illness, or he was in the process of collecting papers and other things. There are some grounds we condone, but ultimately the reasonable cause is always seen for condoning delay. Sometimes it may be some exorbitant delay or inordinate delay is also sometimes condoned for reasons, of course, given in the order. How do you react to the statement is very objectionable. Very question is a recent past incident he is quoted. How do you react to the statement quantum of compensation awarded to doctor is too high? In a breach collapse, 150% died due to the gross negligence of government, and government gave compensation of 5 lakhs to each person. So it was a vicarious liability, therefore government has granted 5 lakh rupees. But the negligence part is concerned, the quantum is always randomly granted. That is my personal opinion. Recently, I granted compensation to a disease, but I adhere to the rules of motor accident tribunal claims. There is a chart given. It depends on the age of a person who died, or the occupation and the income of that person, and what stage he died. Then we calculate on that ground. At motor accident claims tribunal, the chart is given. So I adopted that chart for granting compensation. Otherwise, it is wish of a judge, or it is randomly granted. There is no standard formula for that. That has to be considered. So those are the questions put to me by Dr. Kapoor. I think I answered it. So what we have to conclude, I can say that take care of a record, follow the guidelines given by the latest judgment or the current judgments of a Supreme Court or National Commission or even State Commission, so that we can avoid the litigation. But avoiding litigation is not hands of doctors or a persons who are on the other side. It is up to the complainant to decide. Sometimes they are pampered, they are instigated to file complaint, to blame or to defame the doctors and the professionals. But we can avoid that by following our regular business in a stricter manner, and to follow the norms and guidelines given by the different case laws or the judgments, and we can avoid to some extent. But the filing of complaint is not that way to worry. We'll have to defend that way in a systematic way. There are judgment to help the doctors. So I hope that the Consumer Act is not against the doctor. It is against the erring doctors. So take care of that. And I think by calling me here and giving me this opportunity, I thank to Dr. Kapoor and his team, and I take my leave. Thank you. Thank you very much.
Great round of applause for Justice Tavde. The end part, the last one which you said is that ultimately it is a motor tribunal, means something which is innate, it's been compared with something which is live, and therefore there are a lot of complications and the quantum which is calculated, but at the end it remains with the honorable judge to decide what compensation to be given. And I think there is no end to this, and I'm sure many must be very eager to ask questions, but then we are running behind the schedule. So what we'll do is that the questions will be taken.
So yes, I think, and thank you, sir. And we are going to have more talks. And of course, Lalit Kapoor, sir, will also be covering some points. And we are having a wonderful panel discussion at the end, where certain practical aspects will be covered. But now moving on with the program, may I request Dr. Kishore Adyantaya to please come forward. He is the secretary of FAMCI, and we would request him to introduce our next speaker, who is none other than Advocate Shekhar Nafade. And we have the CV here. Sir, can we request you to come forward? Advocate Shekhar Nafade's CV.
Can I have it?
Yes.
Okay. It is my great privilege to introduce Advocate
On the side of there.
Advocate Shekhar Nafade from the High Court. Mr. Nafade is a senior advocate practicing in Supreme Court of India. He has completed his law in 1973, started his practice in 1974. Initially in the Chamber of
Mr. B.N. Sri Krishna, who subsequently became the judge of the Supreme Court of India. Mr. Nafde was designated as senior advocate in the year 1999. He has appeared in important matters on behalf of the government and other institutions. He has practically handled matters in all branches of law, ranging from criminal trial to tax matters. Constitutional validity of the Maharashtra Organized Crime Act, provision of the SAR FAE SI Act, interpretation of important provisions of the Criminal Procedure Code 1973, Money Laundering Act in review of petition of Sabari Malai case, euthanasia case of Arun Shanbag, etc. From the 1972 to 1983, Mr. Nafde practiced in all subordinate courts of High Court. From 1983 to 2000 in Bombay High Court, and from 2000 he is exclusively practicing in the Supreme Court. Ladies and gentlemen, let me present to you Dr. Advocate Mr. Shekhar Nafde to come and give his deliberation. Thank you.
Thank you, Kishore Anna, and we'll. So do you have slides?
I'm comfortable.
Yes.
Good morning. It's an honor and pleasure to be with you this morning and share with you whatever bit that I have learned. Let me begin by saying that your profession is vulnerable. There are two quotes from Shakespeare which would summarize what your problem is. Evil that men do lives after them, and good is oft interred with their bones. So any mistake that you make, your reputation is tarnished. Second is from Hamlet. There are more things in heaven and earth, Horatio, than that are dreamt of in your philosophy. Why do I say that? Because the medical science is not a perfect science. It is evolving. The new techniques, new problems, whatever that you have learned in the medical school is not enough. You have to keep on updating. Now, my first brush with the complications in the medical world took place not as a lawyer, but as the husband of the patient. We were sitting in an air-conditioned room, and suddenly my wife started profusely perspiring. We all thought it was a heart attack. Dr. Sunawala was a young doctor then. He was a cardiologist known to us. He examined and found that there is no heart problem. After some time, she just vomited something and she became all right. But that was not the end of the story. After that, she started having fever. It would range about 100 and 101. And it could not respond to any medicine. No mycin worked. There is not any specialized field of medicine which we did not take treatment. Cardiology, nephrology, name a specialized field, including some tests which were carried out in Nanavati Hospital. And nobody could detect what was the cause. Until this day, it remained a mystery. Dr. Farooq Udwadia, the senior one, he said that maybe in course of time, we will come to know. This happened about 35 years back. Until today, nobody knows what happened to her and how that After vomiting, she became all right. The reason why I narrated this is because patients do not understand that doctors, not merely as doctors, but as the medical science itself, has certain limitations. The problem is that it does not have the mathematical precision. Now let's come back to my topic. In Jacob Matthews' case, the Supreme Court has laid down a test. It's the 2005 judgment. And what is the test? The court followed a well-known English judgment in Bolam's case of 1957. And the test is reasonable standard of care. If a doctor is to be held guilty, then it must be backed by an expert medical opinion. An error of judgment is no ground to hold him guilty of negligence. Even a small act of negligence is not enough to hold him guilty. These are some norms which Supreme Court laid down in Matthew's case. But I must warn you now, in 2019, in Arun Kumar's case, there is a departure. And this is what requires me to say that now you need a new code, a substantial amendment to the existing criminal laws to deal with the cases of medical negligence. Now, what is the problem? I will tell you what the Supreme Court has said in Arun Kumar's case. It's a 2019 judgment and also followed subsequently in 2020. Supreme Court says now time has come to depart from Bolam's case, that is Matthew's case. The court further says that now time has come that we cannot rely easily on the opinion of medical experts, and the court must apply its own mind. This is a problem. Now I place before you one case, that is Kusum Sharma's case. This is my note of caution. When the court says that now we will depart from Bolam's case or Matthew's case and not readily rely upon the expert opinion, this is my note of caution. Kusum Sharma's case is very peculiar. She had a malignancy in the abdominal region, and she had to be operated. Now there are two techniques. The anterior approach, those who are surgeons in that field would know that I am dabbling in their field. But the problem with we lawyers and judges is that we are supposed to be omniscient. We understand medicine, we understand forensic science, we understand cyber laws and so many things without having any adequate background. Be that as it may, because our law schools, their syllabus is hopelessly outdated. There is hardly any scope for specialization. And now, as far as medical negligence is concerned, we ought to have a specialized study in law school. Anyway, that the anterior approach or the posterior approach. The surgeon adopted anterior approach in preference to the posterior approach. Case was filed. Is it a case of criminal negligence? According to me, if two views are possible, the doctor adopts the one, there is no case of negligence at all.
at all. But unfortunately, these cases are reaching right up to the Supreme Court. When I started my practice way back in 1974, we had hardly heard of medical cases of medical negligence. Now, not a year passes by when I have not appeared in Supreme Court in a medical negligence case. What must be happening in Justice Tavle's court, I can imagine. Now the question is this, that the court wants to depart from Matthew's case. Are we equipped to do so? That's the first question that is disturbing me. Now, the second important aspect, which must be kept in mind. See, medical science is evolving. Now, when you judge a case, by the time it comes to the Supreme Court, it takes easily about 10-15 years. By that time, the medical science has evolved. And not many changes have taken place. What was once considered as a reasonable protocol may not be considered. You may discover the evil effects of certain medicines. Now you cannot judge. Now what I find, again, a problem in law, and that's a problem that we have created, lawyers and to some extent, I may say, with due deference to the learned judges, that you can't adopt the today's standard with regard to a case which took place about 10 years back when the medical science was not that well advanced. So this is one fundamental reason why I feel that there has to be a specialized criminal law which would deal with medical negligence. Now, having said that, is it feasible? Point number one. Now, to evolve such a code, you require two things. First, how much medical science input you put into it. Is it possible? This is the first limitation. Because the techniques are getting advanced, new methods of treatment, new medicines, new problems. So prima facie, it appears that to put medical input into any such specialized law not only bristles with difficulties, but is almost impossible, almost impossible. Then what do we do? Let's explore what can we have an alternative. First, this is an age of specialized courts. We have so many of them. We have a PMLA court. We have consumer courts. We have family courts which deal with matrimonial matters. Even in criminal law, we have POSCO court, cyber offenses, SEBI offenses. Can we have specialized courts to deal with medical science, medical cases of medical? This is one possibility which is required to be explored. Second, who would man such courts? This is a serious problem. I personally feel now that every doctor should do some course in law also. It's absolutely necessary. Instead of we generalists pretending to understand the complications of a medical case, as I told you, the anterior approach and posterior approach. What do we really understand? Nothing. But we pretend to understand and we try to apply. So therefore, first question is, can we have medico-legal, that is people who have done medicine also and law also. We can think of such courts. That's point number one. The second point, see, unfortunately in this country, the people who administer any law really are ill-equipped to do their job. Now, as far as medical negligence is concerned, the patient goes or his relative goes and makes a complaint to the local police station, SHO, the station house officer as we call him. What is his educational background? What is his training? He goes by Lalita Kumari. And he says that all the ingredients of the offenses are set out in the complaint, and therefore Lalita Kumari, Supreme Court says that I must register an FIR. The moment FIR is registered, then by his orientation and training, he goes and arrests the person. Because the reason is that our police force is not modernized. Their level of education, at least up to the level of Assistant Commissioner of Police, is not something which can inspire confidence. Secondly, the legal literacy in this country is in a very awful stage. To deal with medical problems of such intricacies, which courts have recognized. Now that police officer whose orientation was, that man came, gave a threat, took out a knife, killed him, with this kind of orientation, is hardly equipped. How many cases have been registered against doctors? I had an opportunity to appear in some matter which Dr. Kapoor had requested me to appear. A young lady doctor committed suicide. She was charged with 302, that is murder. Now, this is something which must wake us up, that something has got to be done. Now, one case which I remember, and I am indicating to you only for the purpose of inadequacies of the present structure of law, which deals with medical negligence cases. I was defending a doctor, a gynecologist. The lady was brought at some 11 o'clock at night. And she was profusely bleeding, something went wrong. And her blood pressure was falling. This doctor asked the husband of the patient to go and get the blood from the blood bank. He brought that blood with appropriate certificate from the blood bank that this is not tainted. The doctor administered that, unfortunately, that whatever is that period of 90 days or 60 days, I don't know, it was found to be tainted. And that lady contracted HIV. Doctor was prosecuted. Now, what do we do in such a situation? The court was inclined to take a view that he was under an obligation to get it tested. Now, see, it was, and the court was being persuasive, almost bordering on pressurizing us. It was a very difficult task. Finally, I told the client that, look, your reputation is more important. Better settle it. Now, what has happened is, in this case, that there are certain fundamental features of criminal law which are lost sight of. See, the complications in the medical science, correlating them to the relevant provisions of IPC, Indian Penal Code, and forming an opinion is too complex a task, which the ordinary police force is not equipped to handle. A few provisions. Section 80 of Indian Penal Code says that what you are doing is a lawful act, and if an accident occurs, it's not a case of negligence. But I have seen cases where something untoward happens and doctors are charged. Section 81 of IPC again says that some harm is caused, not intended to be caused, but for the benefit of the person, which in this case means the benefit of the patient, not a case of criminality. Section 88 says that if something is being done for the good of the person, then he dies, not criminality. This is where the medical science comes in. That the difficulty is this, that first, what is the condition of the patient? Second, to save him, what treatment is required to be given? Third, what is the degree of skill that is required? Fourth, what are the limitations of medical science? The point that I'm trying to drive is it's a very complex phenomenon. So we simply apply Lalita Kumari's case that the doctor was negligent, and because of that the patient died. FIR is registered. Now these are some of the serious problems which are required to be considered. I remember another case. This was about maybe 25-30 years back, where a well-known gynecologist, that was the days when the test tube baby had just, that science was being developed in India. And in those days, the rate of success was hardly 2%, 3%, or, and she was charged, of course, in a consumer forum. And there again, there was persuasion from the court that tried to settle it. And this lady doctor said that if I settle, that means that I accept that there is some fault on my part, and I refuse to do that. So the matter went on, how much I could learn, our limitations, and how much whatever I learned could put it across to the court, and how much the court could appreciate it. These are some of the difficulties. So therefore, the point that I'm driving is, ultimately, I must say that he was a man from Baroda, and something occurred to me, and I said that, do you read Chitralekha, which is a well-known Gujarati weekly or a fortnightly, I forget now. And I asked him, how did you come to know about this doctor and this treatment? He said, I read it in Chitralekha. So I said, you had read it in Chitralekha, then you also must have read in that very, that the rate of success is, he accepted, and he realized that his case is of, he was not a very cantankerous litigant, but these days in consumer fora, we have a new trend. So the point is that how do we resolve this problem? A new criminal code for doctors is required. There is no doubt about it. But the feasibility, desirability is obvious. The question is feasibility. On that, something is required to be done by the Law Commission of India. This can't be done at an individual's level or a group of lawyers, a group of doctors like yours. This has to be taken up with the Law Commission. We require three things: how much medical science input we can put in, two, what kind of training is required for the police force which would deal with such medical negligence cases, and three, what should be the composition of courts or tribunals to administer such a law. This is a challenge that this country is facing, your profession is facing. We as lawyers have very serious limitations. Before I end, I must tell you one case of Ganguly. I don't know whether Dr. Kapoor, who usually keeps track of all these cases. See, steroid, just to drive home the point, that steroid is something which is difficult to handle, whatever that I have learned. This was a case of what is called as TEN in that is toxic epidermal necrolysis, correct? And the patient went to ordinary MBBS. He administered what is called as long-acting what is that medicine? Steroid, long-acting. The patient's problem got aggravated. He went to another doctor. He, instead of considering whether there is enough accumulation of that steroid in his body or not, started treatment of quick, effective steroid, which led to further complications. The patient's condition became serious. Then he went to third doctor. By that time, his problem was identified. That is a case of TEN. But the third doctor, without adopting supportive methodology, continued the treatment, patient died. Now, what do we learn from this? See, the question is that when you take up a particular job, can you honestly say to yourself that I am equipped with adequate medical knowledge to deal with this case? Or you should say that this is beyond my ken. This is the problem before you. So the point is that when a patient approaches you, he has an implied faith that you are adequately intellectually equipped to deal with this problem. The question of informed consent, etc., these are not very important questions. The important question is this, that can you seriously, in all seriousness, tell the patient that you are equipped to deal with this problem, and the patient has a right to know, which you must respect, that you must tell him this is your problem. And the medical science has limitations, or there is no solution. It's a trial and error method. For example, taking that case of anterior approach or a posterior approach, there is a particular method which involves a high risk, even risk of life. But greater are the chances of recovery. Or there is another method which involves lesser risk, but no chance or a very dim chance of success. What do you adopt? It's a puzzle. Patient must know that these are the two options, and I am going to adopt this. Do you consent? That would be an informed consent. So the point is that the medical world also must wake up and realize that their profession involves certain serious implications in law. The last thing I must say that the legal structure as it exists today is heavily tilted in your favor. I gave you section 80, 81, 88, 92, 93 of IPC, which are general exemptions. Secondly, the burden is on the patient to establish that there is an absence of requisite skill. But at certain stage, see, there is some burden on you also, which has to be discharged. Fortunately for you, as far as criminal law is concerned, the courts have consistently said that the parameters for judging the civil liability and the parameters for judging the criminal liability are distinct and different. It's not mere negligence, but negligence of a gross nature. Now, the real difficulty is this: what is the difference between a lesser degree of negligence and the gross negligence? See, there is a subjective element, bound to be so, because ultimately law is a social science which lacks mathematical precision. So therefore, we have concepts: gross negligence, culpable homicide not amounting to murder. Now, what is the thin line of distinction between a culpable homicide not amounting to murder and murder? In last 40 years in my profession, I can't say this is a litmus test. So this is a problem, fundamental problem. So a subjective element is bound to be there. But that does not mean that there is no area of demarcation. The problem is like when the twilight ends and the night begins. Very difficult. You know the difference between the noon, 12 noon and the evening. But the twilight becoming night, so also. The difference between ordinary level of negligence and gross negligence is very difficult to define. It is going to be fact-centric. It is going to be fact-centric. It is going to be patient-centric. It is going to be the medical science development-centric, and so many other complex factors. And the unfortunate part is that our police force and those who administer the criminal law are not equipped to deal with this. This is the problem. And therefore, you need a new medical code. Thank you very much.
Thank you very much, sir, for that dynamic talk. And you have highlighted some of the problems. I wish we'll be able to find the solutions to those problems. But, that's why they say Lady Justice is blind. But we would like to thank you, sir, if you would come to the center, and may I request our President and Secretary to come forward, and Dr. Badwe and Dr. Smita Sharma to come forward to felicitate our special guest today. Can I request the shawl to be given by Dr. Badwe and the Shrifal by Dr. Smita Sharma? Can we have a round of applause, please? And may I request our President and Secretary to please felicitate our speaker with the plaque. Thank you very much. And now we have none other. Now, of course, we are running a little late, so I'll request our next two speakers to stick to their time, and in around 15 minutes, we will have two more talks, after which we have a very nice panel discussion coming up with experts. But it is my pleasure and privilege to introduce none other than Dr. Lalit Kapoor. Of course, sir is the go-to person from ANC for all our medical legal problems, and he is the advisor for our medical legal cell. And who doesn't know him? But let me do the formal introduction. He's a founder member of the largest body of consultants, which we all know as ANC, and we're all here today with that. He's the president of Famcicon, senior GI and general surgeon. And he had founded the first medical legal cell in the country over 40 years ago, and has been invited by the National Judicial Academy over the period of last 2 years, and also has been speaking to the judges across the country. And he's been the architect of the unique professional indemnity scheme. And I request sir to give us a talk with the practical points. So sir, speak it.
So where is, Mlcon. Yeah, okay. Okay, take it. Okay. Friends, invited guests, I think I'll might have to speed up my presentation because we are behind time. So pardon me if I go a little fast. Yeah, okay. This I've been already introduced, so there's no need. Yeah, now I'm going to speak on the impact of CPA. Sorry, is there a, excuse me, there's a slideshow.
Yeah, this is the slideshow, sir. This is what we are presenting.
Huh?
You just have to press that, yeah.
No.
Yes, it is going that way only.
Oh.
On the screen is going properly, sir.
Huh?
On the
Okay,
screen is
okay,
going
okay,
properly.
okay. Yeah, okay. So I'm going to speak on the impact of CPA on patients, doctors, and the healthcare system, the good and the bad points. Now, very quickly, a brief history of the CPA. On 16th April 1985, the United Nations passed guidelines for its member states for taking measures for consumer protection. Following this, the central government under Prime Ministership of Mr. Rajiv Gandhi enacted the CPA in 1986 by an Act of Parliament. Yeah, it was a great victory for consumerism. Now, consumer, a person who purchases goods and services for personal use. Consumerism is protection of the interest of consumers. In the pre-CPA era, buyers had to follow the rule caveat emptor, let the buyer beware. This then changed to caveat venditor, let the seller beware. So now a seller's market became a buyer's market. Now it is the seller who had to be beware and not the buyer. All of us sitting, is consumerism good or is it bad? All of us sitting here are consumers. We are consumers from the time we are born to the time we die. How can something that is in the interest of consumers be bad? So consumerism is not bad, it is good. Now, a brief history of CPA and medical profession. After the passage of CPA in 1986, several patients across the country filed cases under the Act against doctors and hospitals for negligence, which had resulted in damages. In many cases, compensations were awarded, but expectedly, these were challenged in higher forums and courts on grounds of non-applicability of the Act to the medical professionals. Varying judgments were given. In fact, Madras High Court ruled that CPA was not applicable to doctors. To achieve a closure to the issue, all these legal challenges were placed before the Supreme Court. in 1995, the IMA versus BP Shanta judgment gave finality to the dispute, and it was confirmed that the medical profession was indeed under the purview of CPA. In 2019, a new CPA was passed. Supreme Court reaffirmed that it was applicable to the medical profession. Now, what has been its impact? Since the CPA has been forced for over 3 decades now, we have enough experience, evidence, and material of its impact. However, this question has to be answered in a very balanced and unbiased manner from the perspective of patients, healthcare professionals, and the healthcare delivery system in this country. So we have to see the good and the bad. Just because we are doctors, we can't see only the bad part of it. I will attempt to do this as dispassionately as possible. What is the positive impact? What was the good that happened after CPA? Aggrieved patients have been provided with an additional and simpler avenue of redressal against malpractice and alleged acts of negligence in the course of their treatment. So that's a good thing. Pre-CPA, such a patient could only file a civil case under the law of torts, which could have taken 30 years, under the provisions of the IPC, or complain to the medical council, which of course has no power to award financial compensation. So again, what are the other positives? Enhanced patient safety measures and error minimization has happened. Now doctors have checklists and so on, which has helped. Improved record keeping and patient documentation. It's never been better than what it is today. Even from the interior, Maharashtra, when we get, they have beautiful, good records. Even the RMOs, etc., keep good record. Why this happened? Because of CPA. Role of communication skills has been recognized, and it is added to the syllabus in medical colleges now, how to communicate with the patient. So this is because of CPA. Greater efforts to update knowledge and skills, more CMEs you will find, even though it may be because of points or whatever. Better understanding by doctors of their legal and ethical obligations, and better legal awareness among doctors. So that's why that happened, because of CPA. Also, the realization of the concept of patient autonomy and informed consent, quality assurance and accountability are now the new buzzwords. Stricter controls by hospital administrations. All these were good things which happened because of the CPA. Now, the question of quantum of compensations. Many patients were awarded huge compensations, some of them now reaching the astronomical category. People were getting confused with the number of zeros. They didn't know it is lakh, crore, what. They were counting the zeros. Example, 76 lakhs, 1.4 crores, 1 crore 79 lakhs, 2 crores, rupees 11 crores inclusive of interest in the Kunal Saha case, which Mr. Nafde mentioned, highest award so far. This transmitted a variety of messages to patients, healthcare professionals, and the system. And some of these messages were good and some were not good. What transmitted? This high compensation. What message did it give? All right. Now, what is the basic concept of compensation? The principle of restitutio ad integrum, under which a person who suffered damage due to wrong committed to him ought to be restored to the position in which he would have been had the wrong not been committed. That is the principle of compensation. But of course, there are double standards here. As I said, suspension bridge collapses in a place, 150 people died, and 4 lakh rupees compensation awarded by the government. Gujarat High Court has told the government if 4 lakhs is nothing, it should be at least 10 lakhs. In one case, 7 children lost both their parents. And what is the compensation? 3,000 rupees for a month for the rest of their life. Now, and whereas a terminal cancer patient who would have died definitely within 1 year, he dies and the doctor is about 30 lakh rupees compensation. So there is some kind of mismatch which needs to be corrected. Now, the people who justify this huge compensation, how do they justify it? Why do they say it is very good, high compensations are good? There is some very good justification they give. Large compensation payouts send out a strong message to negligent or unscrupulous hospitals and doctors and acts as an effective deterrent. Large payouts are the only way of improving healthcare in India. Medical councils have failed to regulate the conduct of doctors. Large compensations would ensure better patient care. Now, to some degree, I'm in agreement with this, and I will tell you why. I'll give you only one example. There is a disease, those who are pediatricians would know, called ROP. ROP means retinopathy of prematurity. In premature babies, they get a ROP disease, which the child becomes permanently blind for life if it is not detected in time. And some of these two of the huge compensations which I mentioned were in cases of ROP. The pediatrician was awarded 70 lakhs, 80 lakhs, 1 crore for the parents of the baby who developed ROP. Why? Because they failed to detect it in time. Now, what has happened after that? After that, pediatricians, neonatologists who heard that 76 lakhs was given, every premature baby immediately, immediately, first do this, do the eye checkup. So many people, so many babies would have not lost their eyesight. So to some extent, there is some sense in what it says, or what their justification is. But I will tell you what is not correct about it. So what is the flip side of huge compensation? That was the good side. It is important to remember that though compensations will deter carelessness by doctors, it will also deter the desirable risk-taking involved in crucial medical decisions, which may optimize chances of recovery of the patient, especially in life and death situations. Life or death situations, I will say, I might get liability, sorry, and people, that might happen. Fear of being foisted with liability will take away what may be the only chance of recovery of the patient in a given situation, because doctors are scared of huge compensations. So that is the flip side. Now, there are those whether inclusion of medical profession under CPA is appropriate. This is an academic question because we are under CPA, there's no question. But those who argue that this is an inappropriate grievance mechanism for patients say, does it stand to reason that a life and death profession meant to heal human bodies is equated to business and commercial enterprises? Is it not demeaning, insulting to both patients and doctors to be brought to the level of customer, grahak and seller? You're a buyer and seller, and patient and doctor are the same. Is it not demeaning to both? Whether complaints against defective TV and fridges and the errant builders should be categorized along with complaints of adverse outcome of treatment of patients. How does it look, a heart surgeon rubbing shoulders with a builder who didn't deliver his flat in time in the consumer court? How does it look like? Tell me. So this is something, this is those who feel that it is inappropriate. Also, medical is a complicated science dealing with a complicated machine. Mr. Nafde also mentioned several times, medicine, doctors practice an inexact science, one that is subject to countless variables that can produce unpredictable and sometimes unfortunate results. In the era of high-tech medicine, the expectations of the public from medical science have risen sharply, sometimes to unrealistic levels. Now, what is the impact on healthcare professionals of CPA? It did some good, it was good, not all bad. The tendency of doctors now is to look upon every patient as a potential plaintiff. The excessive focus on documentation and doing the medico-legally correct thing, not the medically correct thing, but the medico-legally correct thing. High escalation of healthcare costs leading to defensive medicine, about which I will talk. Increased indemnity insurance. When I started practice, my premium was 150 rupees. Today it is 30,000 rupees. So these will keep going as the claims increase. And ultimately, is it passed on to the end user or the consumer? From where am I going to get that money? From the patient. In getting acquitted in a case of consumer court after several years is still a no-win situation for a doctor, because the process itself is the punishment. After 10 years, I won the case, but I got punished enough. Never mind if I won. There's no cause for me to celebrate still. claims CPA was supposed to be speedy, inexpensive method of justice. They said in 90 days, the judgment would come, but now it is closer to 90 months. And it is far from inexpensive. The doctor spends lakhs of rupees on the litigation defense cost. The patient spends lakhs of rupees, right? So it's neither inexpensive nor speedy. Now, a day may come when doctors here might start putting up a sign outside their consulting room like this, which is there in the USA. He says, if you want to consult me, please bring your lawyer along with you. Good for lawyers, they'll get more work to do. Okay. Now, what is the unfavorable impact on healthcare? Faith and trust are key ingredients in the process of healing. CPA has resulted in a serious trust deficit between patients and doctors. The mutual trust has in fact been replaced with mutual suspicion. The patient is a customer or a grahak, and the doctor is an HCP or a healthcare provider, much like internet service provider or XYZ provider. There has been an exponential rise in litigations against doctors. Adverse or suboptimal outcome of treatment often gets equated to negligence or what they call deficiency in service. Patient hostility and aggression registered an upward trend leading to fear psychosis amongst healthcare givers. And then, of course, is the practice of defensive medicine. And what is defensive medicine? Defensive medicine means doctors ordering tests and procedures, making multi-specialty references, taking other measures, not because the patient needs this, but in order to protect themselves from any potential malpractice liability. In earlier years, for an operation, I would ask 3 or 4 tests before the operation. Today, I ask for 20 tests. In the USA, 82% physicians order more tests than are necessary. $650 million are lost by American healthcare system because of unnecessary tests and procedures in the process of defensive medicine. A similar effect is on the way in our country, but this is something which a resource-challenged country like ours cannot afford. We do not even know how many crores we are losing as a result of defensive medicine, how many unnecessary tests we order as far as this is concerned. And what has happened in the healthcare sector as a result of this fear of doctors? Several super specialty medical seats are lying vacant in medical colleges. Students don't want to go for super specialty there, which are more considered more risky. The government jobs, hundreds, thousands of government jobs are vacant. The government is trying to offer 1 lakh. I saw the advertisement the other day, 1.5 lakh, 1 lakh. Please come and join if they are lying vacant, because people don't want to join, particularly where there is no infrastructure. Apart from risks of litigation, the bigger risk of facing physical violence is deterring students from taking up medicine as a career. And most doctors are not encouraging their children from becoming doctors. Now, I can only give you my example. I have 2 daughters, and my wife and I, we run a hospital. So we tried to persuade daughter number 1 to take up medicine, become a doctor. She refused. She said, I don't want to become a doctor. Daughter number 2, we tried. She also refused. I don't want to become a doctor. Then we got a brilliant idea. We said, don't become doctor, marry a doctor. They said, we will not even marry a doctor. So that is our position. And now I do not know what to do with my hospital. Okay. Now, experienced doctors retiring early. So what's the negative impact of this? What is happening to our healthcare system, which ought to be known to everybody? Experienced doctors are retiring early, which is a severe loss to society, which is already facing a skewed doctor-patient ratio. Small and medium-sized nursing homes are shutting down, worsening the hospital bed population ratio. And there are people who are giving away their nursing homes. The next speaker what she's going to talk about is direct result of this. Bright students are not finding pursuit of medical profession attractive, and therefore the quality of doctors will plunge. doctors are switching to other professions. Yeah. So what are they doing? They are becoming practicing advocates. They are very comfortable, very happy. They are very happy. Many doctors have become advocates. I have seen some of them. They have a very good smile on their face. Why? He says no night call, no CPA. Mainly no CPA. Advocate, no CPA. The police, people are joining. Some IPS, I have seen doctors, hospital administrators, insurance, pharma industry, builders. I know doctors become builder, hotelier in Andheri. There is one of our anesthetists who started a hotel. He's doing very well. Music director in Goregaon, we have a music director. Dr. Badwe knows about it. He is doing very well and sends me his music sometimes. Politicians, ministers, they have become ministers also, though they have not helped the medical profession, but they have become ministers. Share brokers and an odd person, and I also seen some doctor become godman, what is called spiritual guru also. They are doing very well. There is somebody, is it not? There is somebody, yes. Sir, they have become spiritual gurus. They're very happy. So doctors are shifting to other professions. Now, this is important. This is for the judicial people. They must consider this. And Mr. Shekhar Nafre is not there. I thought he would be there. But this is important. Should not courts factor in the terrible lack of healthcare infrastructure in our country while upholding the charges of negligence against the doctor? Government spending on healthcare infrastructure is a miserable 1.28% of the GDP. Lesser than many underdeveloped African countries. Brazil, even Bangladesh is spending more than us on the healthcare. Should we implement a first world regulatory structure, namely large compensations like in USA, in a country with pathetic infrastructure, poor blood banking system, shocking lack of qualified nurses and paramedical personnel, non-existing emergency response system? Here an ambulance takes hours to come. Sir, an ambulance will take 1 hour to come. Where was he? He said, diesel bhar raha tha main. They don't come. And I have seen the quality of ambulance. I have seen one ambulance which said, ambulance come hearse. And in Western country, it will not qualify for the hearse also. They are so bad. The primitive ambulances and so on, which leaves doctors hamstrung in exercising their professional skills. To summarize, the good that has emerged from post-CPA, CPA is a welcome legislation which has helped protect consumers and consumerism. It has provided an additional grievance redressal mechanism for patients since healthcare services are within its ambit. It has helped regulate healthcare in a number of ways which have benefited the patient. But what is the harm that it has done? And I will not say what harm it has done. I will allow the ex-Chief Justice of India say. Sir, this is what the ex-Chief Justice of India said. I am not saying these are not my words. Justice Ramanna on 24th August he said at the National Academy of Medical Sciences, you can go to YouTube. This is his word, not my words. What he said, doctors are shifting to foreign countries, unchecked corporatization of hospitals, lack of secure working environment for doctors, namely violence, high cost of healthcare, and these are his words, sir, it can be checked up. Several false cases are being lodged against upright and hard-working doctors. These are his exact words. This is Chief Justice of India. These are not my words. So this is the bad impact. And I'd like to conclude, undoubtedly, everyone doing a responsible job must be accountable for his or her actions, especially in a profession like ours. CPA was applied to medical profession on account of lack of auto-regulation, I admit. I have highlighted the good impact and the not so good impact of CPA on our healthcare system. It may be worthwhile modifying CPA provision, what Mr. Nafre was trying to say, by examining modalities in other countries, including no-fault liability, capping of compensation, creating professional tribunals, establishing public fund for compensating medical injuries. And lastly, the final message, which I would like to give and which I had given to in Aurangabad. Sir, Justice Tavde was present, where there were students, and I didn't want to disappoint them, who are budding doctors. I said, finally, CPA or no CPA, the message for all doctors is that we belong to a very glorious and proud profession, one that was the most respected profession. We must all strive to restore the honor and dignity of our profession by isolating the black sheep, by practicing ethically, and by being humane and compassionate doctors. And our hearts should beat for the patient with empathy like this, and not mechanically, like this. Thank you, ladies and gentlemen.
Thank you very much, sir. That was a talk straight from the heart. And I think, sir, you have really, sir, please wait here. We would like to felicitate Dr. Lalit Kapoor, who has been the heart and soul of today's program. And we would like to felicitate him. Can we all have a big round of applause, please? And thank you, sir, for sticking to time. And I would, last but not the least, we have our speaker who is, can I have the slide? Yeah, and sir ka pen right there. Dr. Sangeeta Pikle is actually my colleague and friend from residency days. And she's one of the doctors which sir has mentioned as our president also, who has qualified as a LLB along with medicine. But I have the pleasure of introducing her today. And Sangeeta Pikle is a practicing OBGYN and is the director of Pikle Healthcare Private Limited. She's the director of Maharashtra Healthcare Skill Sector, past president of AMC, and in her year she had done a wonderful job. She's the past member of the State Supervisory PCPNDT Committee, past advisor of TISS School of Vocational Medicine of Education, and she was a graduate from Sion Hospital, postgraduate from KEM, and has done endoscopy training and a diploma in hospital management and LLB from the Mumbai University. And Sangeeta, in the next 12 to 15 minutes, is going to talk to us about how we can, what are the issues she has personally faced in, she has personally faced in renting out her nursing home premises. So Sangeeta, over to you, and let's welcome her with a round of applause. Come.
Let me bring you a notice that we never ever have had a lecture on renting out premises. Justice Tavde, to get your notice that a lot of doctors are renting out their premises now. We have a lot of people shutting down, and that is why first of its kind lecture on renting out your premises. Never before in medical history have we had these kind of lectures, sir. But now we started training our doctors how to shut down practice.
So thank you for the invite, Nilima, team, AMC, the medical legal team, and the stalwarts here. I feel like a fledgling after such amazing talks the whole day by the legal, bigwigs, I would call them. And the only thing, so I had prepared a talk. I had prepared a long talk of do's and don'ts, which was there till last night. In the morning at about 6 o'clock, I got up and I just thought that if I tell you the do's and don'ts, had I done something terribly wrong? And I hadn't done terribly wrong. I had done everything in the book as for do's and don'ts. So what all had I done? First of all, I was 51. People ask me, why at 51 did you rent out your nursing home? Someone time me. If I'm exceeding, you can just tell me. Yeah. So, so somebody said, why at 51? I was 51, husband 55 around that time. We had about a huge practice, actually, a very, very huge practice. But it, like sir said, getting tired of it. 30 years of practice, beta doctor nahi hai, America mein settle ho gaya, yehi subah sham karne ka, bill bhi dekhne ka, and everything dekhne ka, it got tiring. Plus, the medical legal thing looming so hard. Every few days, we were stressed out. Whether something goes wrong with the patient, will they sue us? So we decided, and I did a homework. I met up Dr. Sunil Vaze, who exited a nursing home, Dr. Gokte, who exited a nursing home. I met up with Anand, a lot of advisors helped, a lot of do's and don'ts from everybody, including one doctor who gave us, two doctors who gave their place on rent and got in trouble. So I met all of them, did everything right as per the book, all the research and everything, and I still went into a huge disaster. So why? Okay, so why me? Am I an expert? Now, I am not an expert. I'm just someone who survived, a victim who has a story to tell. So the disaster also was followed by a fair victory. LLB gave me the advantage. COVID, I mean, people were cursing COVID at the time that I was happy. I could drive on the roads as a doctor. My court case was going on. I could drive on the road with that lal, whatever that sticker, and people wouldn't stop me. And in the court, defendants and plaintiffs are not allowed. So I used to take my LLB card and go up. I used to wear my black trouser and my white shirt to look like lawyers. And in an empty court, I could meet up with the judges faster and I could move my case from an offline to an online. I made visits. So I converted my case from offline to online as per the Supreme Court, directions. I visited the courts over 200 times, including lawyers, statutory bodies, etc., and met hundreds of victims. Over 700 visits from police, fire, BST, I don't know every particular department. 5 lakh rupees on Xeroxing, printing, petrol of about 4 to 5 lakhs. I'm not mentioning the lawyers' fees, but I met over 54 lawyers, paid 22 of them. Engaged lawyers for criminal cases, civil writs, and over last 4 years, assisted over 30 to 40 doctors in their decision to rent or exit. But I still didn't think I was an expert till I know Sir called me in end of December. Dr. Kapoor sir called me and he said, Sangeeta, I was in Rahej, I got the phone. And so that was a degree you gave me because you said, I'm thinking of renting out the property. And then you discussed with me and I said, yay, I arrived. Sir asked me a question. So my experience over the last 4 years has been what movies are made of. If you haven't seen Arakshan, you should. Because everything in Arakshan I thought is a myth, but everything in Arakshan movie is what happened to me. Khosla Ka Ghosla, any of these movies, and it's all happened to me. I have faced police complaints in MRA, Mumbai 1. I have faced police complaint in RAK, Rafiq Ahmed Kidwai. I have faced police cases in Mahim. In numbers, you can't imagine. So I have cases, I have litigations against me in the, so there are summons cases in Bombay, 9th Metropolitan Magistrate, Ballard Pier, Esplanade Court, and I don't know many. So I realized very late that my property was 8,500 square feet, convert into 40,000 per square feet, freehold property land. I was a sitting duck. I and my doctor husband, Hemant Pikle, we were living on the 3rd floor. We had the ground, the basement, the 1st and 2nd as nursing home. We had a huge practice, but I never ever realized ki dhata gharachi kimmat karat nahi. And I didn't realize what I was putting at stake. I just thought I was giving my business on rent and I could continue my clinical practice. Now the do's and don'ts are coming out of my stories and therefore there are don'ts for you. People say, how could you make a mistake? And there are people who said, Sangeeta, kuch to, it doesn't fit. So let me tell you, I trusted a colleague consultant would not bring a bad person. So I had this consultant with me for 15 years, my physician admitting and, managing his patients in my institute. And he had got this party to me. We had over 10 or 12 people who had come to us. So we had a lot of people who wanted in the brownfield acquisition phase, coming with various offers to us of, being able to do business with us. And I trusted this consultant, made a mistake. I trusted that public listed company, which are registered on SEBI, BSE, will be safe because the company I signed up with was a BSE listed, public listed company with SEBI registration. I trusted that the main promoters, if they're healthcare professionals, I can't go wrong. The promoters were, I won't take the names, the promoters were healthcare professionals. I trusted that a Marathi surname with an 8-year-old child promoters, changli log hai, family people, they can't be criminals. I made a mistake. I trusted that the company secretary who I assisted, gave the job of doing a due diligence, would look into the accounts and not give me superficial answers. I trusted that a reputed drafting lawyer means impeccable drafts. I trusted that the police will protect the lawful owner. I trusted that MCGM will not give registration to an unlawful occupant with no valid leave-in license. I trusted that a registered stamp duty paid legitimate agreement is safety. What due diligence did I further do? I asked our chartered accountant, my chartered accountant of 10 years who knew this party, I asked him, do you know this party and what do you know? And his reply, because we met him and he said, oh, they are very good. They are in the healthcare. They've got great funds. They have put 80 crores for the business, this, that. Now, after all the debacle, the same chartered accountant says, Sangeeta, मैं ऐसा बोला नहीं था. मैं बोला था मैं उसको बराबर से नहीं जानता. Story changed. I asked a company secretary to do the company checkup. The reply was the company account seemed clean. Now she says, there is a lot of window dressing. There's a lot of fake accounting. There are a lot of accounts which are completely fake. They are not true. I asked the physician who got them, and he said that he knew them. And later on, I found that my physician, who was with me for 15 years, was just an agent. He took 10 lakh rupees as commission fee for getting them into my property. And I have evidence for everything I say. More due diligence. I engaged a big lawyer for drafting who charged me 1 lakh rupees. I visited, sir, I will not take the name now, but I visited one of our old AMC strong lawyers for reading the drafted agreement, because I was told that litigation lawyer ko dikha do, better hoga. But the litigation lawyer asked me for 1 lakh rupees. I made a mistake. I should have taken it, but I did not. I spent 1 lakh to read a draft. I can read English and I can have some friends read it. So I did not pay that lawyer and I did not take that, validation from a litigation lawyer. Now, there is a difference between litigation and drafting lawyers. Drafting lawyers are like checkup wala doctors. They see healthy patients all the time. They don't, always pick up the clinically sick patients. Whereas a clinically practicing doctor will pick up the slightest signs much better. And therefore, a litigation lawyer, when they read a drafting lawyer's draft, finds 10 mistakes to 20 mistakes and says, "Arey, idhar dispute hoega, udhar dispute hoega," something which I learned retrospectively. We exchanged over 10 drafts and missed a pattern. Now, this is very interesting, and I think everybody should realize this. That is, I think I'm intelligent, but I've made mistakes, so I think I'm not as intelligent as I think. We exchanged, I've written, mails. So we kept on exchanging drafts. That's okay. So we kept on exchanging drafts of the leave and license agreement. So somewhere from about August 2017 till about December when we signed, we exchanged over 10 to 12 drafts. But our mails, when we were being exchanged, I did not realize that somebody comes to cheat me how he works. So there were about 10 different email IDs. I would send a mail on one, the reply would come from someone. I did not realize that till I went, into litigation. I kept doing that. The other thing they did, very important, they would do corrections. We had agreed, both of us, to do corrections or alterations in track mode so that we can see what are the changes made. So what they would do some corrections in track mode and some corrections not in track mode. So if I put it on, I feel itna badli kiya hai, and I would look at only those. It is very late I realized that some of them, they had done track mode changes and non-track mode changes, something that if somebody is doing exchanges with you, this is something unheard of, but I suppose people who come with a dirty intention can do all this. The final draft, this is one of the greatest mistakes I have made. The final draft of our agreement was brought by my licensee to the registration. What happens? You start trusting those people. You are, tumchi mulgi deta hai lagnala, tar vishwas ka thevnarच मुलावर. That is how it works. You are giving your property, you start trusting those people. A word that I think is dangerous in property. There's nothing called trust. This is an object. You have to be very particular. You cannot get blind at any moment. But I made a mistake. They brought the draft agreement for signing. What did they do? And which I didn't realize at the time we signed. I realized it much later. I've always said, I think Dr. Kapoor and I think Nilima, and I think I've heard many people say hindsight is 6 by 6. So this hindsight information that I'm giving is for you people to know that you should have better foresight than I did. So now they changed the draft. In English language, in the law, the word may and shall has a different meaning. The may and will has a different meaning. And what these people did was when they got the final draft and the annexures, which we had shared on the previous day as, final, what they brought was edited versions of those. The words may were shifted to will. So there was a word saying that we may extend the leave and license for another 4 years. They made it, we will extend the leave and license for another 4 years. They had changed certain statements by which it looked like as if it was in perpetuity. So they did change, but fortunately, and this is where I say, I also missed on few things. We agreed, they said, oh, we are a big corporate, and they showed us some big office. I went to Andheri office, I saw it. I didn't realize that was a lease, udhar bhi bhada bhara nahi tha. It took me a long time to realize कि वहां पर भी तो भाड़ा नहीं भरा था, but how would I know? I didn't go meet the licensor. I'm now doing all those things for people on many occasions. One of the clauses, so there are certain clauses that are very important for your leave and license agreements and otherwise. Now they said we will pay RTGS or checks. We did not take post-dated checks. Big mistake. We missed clauses for the per day delay in vacating after revocation. We missed many small protective clauses that we are now aware of. But the saving grace, then what saved us was impeccable revocation clauses and breach clause. Fortunately, at every reading, 1-2 clauses I never missed out were these clauses, and I realized they have saved my day. Impeccable clauses on our access to our third floor home and all premises. We lived a movie which people find hard to believe. We had no staircase access for our home from 8th November 2018 till 30th November, till one of the senior police officers. We had to go by lift, forced to go by lift, and then they would switch off the lift and me and Hemant would get caught in the lift. We were rescued multiple times by our own people, but on 2 occasions, we got fire brigade to rescue us. One of them was I had to go to Guru Nanak for a call at 9:30 at night. And I've never taken Hemant along with me for a night call, but that particular day, obviously we were already in trouble. So we had got both of us leaving and they switched off the lift. We were caught in the lift for over 5 minutes. And in the night, I didn't have too much support system. I had a bacha watchman, that all-in-one man who works for me. So what we did was we called fire brigade. Fire brigade broke the lock, broke the grills, rescued us, and we got a fire brigade report. Again, very useful. It came in our case later on. Our meter room caught fire in 2019. And for all of you who are worried about fire NOC, fire compliance, these people's fire NOC, somebody, whoever is interested can come and see the papers. It's like a museum. I have a full room. I have a full staff working for all this. I'm out of pocket for everything, including my expenditures of beyond 1.5 crores. And I know I did all this. People take 14 years to do it. I have done it in 2.5. So it sounds big. But jab 14 saal, 15 saal case chalta hai, to utna hi hota hai. So I think I've just done it in a concentrated form. But this fire compliance is very interesting. 4th of April 2019, they apply in the morning for fire compliance. 4th of April 2019, an inspection is done on paper. 4th of April 2019, internal comments are made. 4th of April evening, a senior fire officer signs. 4th of April, a certified copy is given to the opposite party. Efficiency, thy name is my opponent party. Their nursing home registration. 3rd of February 2018 morning application. 3rd of February 2018 morning application, inspection, internal comments, nursing home registration given on the same day, including certified copy. I can give you all these documents. These documents will show how far power, political power, police contracts, money and payouts. So I say the PPP, the politicians, the police, the power and the payouts, all of them go together and you can see miracles. Anybody who wants to see these RTI documents that I have. Okay, I have made a god and all my books I used to, when I was small, I used to write Om. Now I write Om and I write RTI because most of my information of what is happening behind my back, what the officials are doing, what the police is doing, what the judiciary is not doing, what anyone is doing was through a single tool. And I have to thank Dipesh is not here, Dipesh Savla. He taught me right to information very early. And then over the years, I mastered right to information. And I have used multiple ways of getting information. And I think the one thing we all need to protect is right to information. They also made this place a COVID hospital. They threatened us. They would have staff and patients when we would leave the house. They had CC cameras everywhere. So every time we left the house, they would see that staff and others would come and try to cough on us. This was a regular feature. I faced 2 MPs, 1 MLA, 1 sitting corporator, 1 DCP, 1 ACP, 2 senior PIs, 1 PI, 3 APIs, all supported them. But I want to mention 2 officers who really stood up for us, for the rightful owner. And Shri Ravindra Shisve, Shri Viresh Prabhu, wherever in my life, I'll be always praying for them. They were the officers who opened the door for me for going to my own home. What do I have do's for you? Do's is one thing, never give up. It's your property. Never get frightened. सामने वाला सिर्फ डरा सकता है, कुछ कर नहीं सकता है. तुम डरोगे तो हारोगे. Property renting mistakes. Yeah, document everything. I'm obsessive compulsive disorder for documentation, and that helps. So I've had times when an officer has threatened me, oh madam, तुम्हाला माहिती आहे का license तुमचा आमच्या हातात आहे. Verbally बोला, next day मैं letter भेज दी. I met you yesterday 4 o'clock. You said, oh madam, तुमचा license आमच्या हातात आहे. What did you mean? I did not get sleep. I'm very scared. Are you telling me that you will not give me a license? I've shot such letters to officers. And the officer will next time not threaten me. He doesn't even answer because it's usually very polite. I'm not talking as politely as I write politely. Okay, Reena tells me 2 minutes. Can I take a little time if the audience is okay? Okay. So I met lots of victims, just many, I think hundreds, 200s, I don't know. Hindsight, like I said, is always good. You have to do better background checks, including private detectives. I know about 2 of them who do all these things also now. You have to take higher deposits. You need to take PDCs. You can use the Negotiable Instrument Act for it. Always carry the final draft by the licensor. Take the annexures yourself. Do not rely on word of mouth reference. I have seen people are politically right when they give you references. Later on, if you dig out, people don't tell the truth. Speaking openly, speaking transparently isn't a human tendency. Net search. For each director, do past litigation searches. I have learned so much that when my son found a girlfriend and he told me her name, I found out the girlfriend's father's name, brother's name, mother's name, sister's name, address, everything. And my son said, you become creepy. I said, no, times have taught me. So now I can find out if you are on the net, I'll tell you how you can search up people. When we gave up our place, so what was my worst decision? My worst decision was I had 62,000 patients, I OPD, 2,500 admissions and about 1,000 surgeries a year. I was 51, he was 55, we were tired of the business. We had run it for about 30 years. I should have just made it a surgical hospital. I would have been happy because most of the rest was medical. But my decision was, itna kaise chalayega? So I didn't apply my mind very carefully and made a big mistake there. Each person has to think very well about giving out the rental properties. You please work out your finances well. Return on rental is barely 2 to 3% in residential and 6 to 9% on an average. Liquidity. So there are these things. I think I'll just skip this. Litigation can take 12 to. Okay, he says, okay. So sell, invest and have liquidity after 70. You need only a living home and maybe a holiday home. At the holiday home formula is only if you use it at least 20 weekends a year. So my holiday home in Goa, I'm putting up for sale next year. Most of today's generation kids, especially those abroad, do not care for our property. So sell it. Probate is like handing trouble to the children. Medical or non-medical renting. Renting is a risk. It does not matter whether it is a medical party or a non-medical party. Litigation takes 12 to 20 years. I have got a book which I gave few people, but I'm going to share it, which is a beautiful book written by Prabhakar Karandikar. I think some of you should read it. Any arrangement, be it legal license, lease, conducting agreement, management, profit sharing, all are fraught with their own troubles. Disputes can happen everywhere. Know your title clarity. A whole lot of people who had MHADA properties were wanting to rent it out. And I was like, MHADA is not your ownership. How can you rent it out? So when you are in what is called as a not a clear title, don't risk your property. Know your financials. Know why you want to hold your property. Company and LLP are complexities that you have to understand very well. Huge mistake I made in understanding that companies are good. When you read this book, you'll realize most of the companies, when they acquire property, never leave it. Whether it's even if it's a bank, they don't leave it. Do save accepted deals. No jugaad for saving GST, stamp duty, registration, because more jugaad, more litigation. More is you on a weak wicket. Documents, extreme diligence helps litigation, but does not prevent litigation. Police, MCGM, fire, judiciary, unfortunately, and I'm sorry to say, sir, but it feels like I'm victimized by the systems because criminals are powerful. They yield more power. A doctor should live a doctor's life. I may exceed. Do you want me to stop? Okay, I'll continue. Yeah, okay. So landlords are a troubled lot. I don't want any doctor to be a landlord. If you want to know whether landlords have better life than doctors, just come with me to Small Causes Court and meet up with just 20 landlords. And then you'll see. So I have this friend of mine who's Mr. Hingwala. There's a Hingwala lane in Ghatkopar. They own over maybe 100, 200 apartments. They are lower middle class, or I would say just about middle class, and just struggling to get back their properties. If they get back all the properties, they're 1,000 crores worth. But otherwise now they're just fighting all cases. They are landlords. real life stories. I've got 3 here. And this is Surgeon S. Now, this is a very intelligent Surgeon S. I can stop. Fine. No, I asked 2-3 times for the same reason. So fine, there are 3 real life stories. What I will put it up into maybe one of the grass magazines and you all can read it. Beg your pardon? Yeah, I heard you. I'm wrapping up. You could give me 30 seconds for that? Thank you so much. So what is happening now? And this story, I think the reason I was also rattling, like I said, I had a different presentation. I went here simply because I realized that with all do's and don'ts, you can get into huge trouble. And therefore, don't get tempted by rents. It is not easy income. And anybody who's wanting to get into rents, please come into my little museum of all case laws and everything. I'll be there to help you. Thank you very much.
Sangeeta, thank you very much. Just wait. It was a very, very interesting presentation. And I think over lunch, we are going to have more discussions over that. And on behalf of today's program team, I would request our president to felicitate you. Thank you. Thank you. Thank you very much, and thank you. We would have loved to hear you for a longer time, but you've really done a great job in the short time that was available. Can I have Dr. Sudhir next? It's now my privilege to introduce Dr. Sudhir Naik, who is one of our past presidents, and he's a very dynamic person. All of you know him, but we'll have this. Sudhir, no, let's, and yeah. I'll be brief. Yes. Yeah. And Sudhir is the chairman of the medical legal cell of AMC, and he's been doing a lot of work. He's a trustee and past president of AFG also, an honorary gynecologist at HBT Trauma Hospital. And Sudhir, in the next 45 minutes or so, is going to have a wonderful discussion with panelists. So I'll hand over to him to introduce and call our panelists to please take the dais.
Thank you, Reena, for the kind introduction. And I think we will go ahead with the panel discussion as we are already running behind schedule. I will first invite my first panelist, Dr. Satish Bhatt, who's come all the way from Bangalore to us. He's a member of he's a plastic surgeon by profession, and he's also a co-founder and managing editor of whydoctor.com and an online platform for medical events. He's a qualified advanced mountaineer, and I'm sure he'll be able to give a lot of inputs on the topic which we have today. May I invite the next speaker, Dr. Sujata Rao. Again, she's somebody, please have a seat. Satish. Dr. Sujata Rao is our past president. She's, I don't think really this audience needs any introduction to Dr. Sujata Rao. Please, a practicing ENT surgeon in Kandivali as well as in Holy Spirit Hospital. I invite Advocate Jaiwant. Advocate ND Jaiwant again is one of us. He's our panel lawyer for the AMC Professional Indemnity Scheme. He has been our well-wisher. He has attended almost all our programs, and his inputs as far as the Consumer Protection Act is concerned, I think have been very useful. He has been able to get a lot of our members exonerated. His legal qualifications, I think I've already mentioned. He's been practicing since 1980 and has represented various companies in High Court, Bombay, and many other courts. And he's a member of the panel of advocates of Association of Medical Consultants since 1995. May I invite Dr. Sugandhi Iyer. She's the Deputy Director of Hinduja Hospital, NABH Principal Assessor and faculty at NABH workshops. She's the visiting faculty in law, participated in over 350 workshops, and has penned over 150 articles regarding medical legal aspects of healthcare. I would also invite our president, Dr. Nilima Vaidya Bhamre. I don't think anybody needs any introduction to her. A practicing obstetrician and gynecologist in Kandivali, as well as a lawyer in her own right by profession. Dr. Umesh Oza unfortunately could not join us for this. He was one of our panelists. So I have requested with Dr. Kapoor's kind permission to invite Dr. Ashok Shukla, our president-elect, again a practicing obstetrician and gynecologist by his own right, as well as advocate by profession, by qualification. Our topic today is optimizing the response from a legal notice to the consumer forum. Now, my question to all these panelists is, we as doctors always believe that primary prevention is better than anything else. So are there any particular risk mitigation points which our members need to be aware of when they decide to start practice and when they are dealing with any patient? We had one of the speakers today talking that every patient is a potential litigant as of today. So, but is there any way that you can screen your patients to try and identify who is more likely to be a potential litigant for you?
So as you rightly said, every patient has to be seen by litigant because you don't know which patient will find a case. But there are some patients who are more prone to be litigant. Patients who come and see doctor inpatient appointment bed basi. ये medicines की safety कितनी है? What are the other options? Your charges are higher. ये will be more chances of filing a complaint against you if there is some amount of error from your side. So you can start screening that way and slightly give more time to them, or maybe involve more specialists and references compared to what you might do in the other.
Dr. Sujata, would you like to add something to this?
I think it is open to doctors.
Yeah.
So we can categorize, I think, based on our experience, the number of patients who are presenting to us. So there are some who are highly intelligent, who will come with number of questions, who will come after, consulting multiple doctors. They give you the history. They also come and criticize other doctors. So these are red flags. I think these are the pointers that you should be careful with. There are second, very opposite in the spectrum, who are absolutely not educated. They come with blind faith. So their communication is an error, where they may not listen to what you're saying. They may not bother about the complications. They just want an assurance that everything will go right. And then third is those who come with relatives who are inverted, they are in quotes. They may be highly influential people in the society. There may be some leaders. So, or they may come with different relatives at every visit. So these are the red flags according to what I have.
Yeah, Satish.
There is another dimension to decreasing risk even before the consultation begins, and that is what we can do at our end. So, for example, I believe it's easier to change ourselves than till the system can be changed. So, get the best possible training or qualification. Don't step outside your scope of work. One another practical thing that I've done is, as far as documentation is, I have a CCTV within my consulting room with a screen that separates the patient examination area and a microphone in my desk which records all the conversation. And there is a notice outside in the waiting room as well as outside the entry to the clinic which says that it's under CCTV surveillance. So this stays for a month, typically by which red flags can be identified. So this is just another perspective besides killing the patient.
Anybody wants to add anything to this? I think so. Basically, what the panelists have said is that though we understand that each patient is a potential litigant, there are certain red flags which will make you more aware, which will make you more careful. So timely referral to a super specialty hospital or taking a second opinion will be there. Your documentation of your work, of whatever advice you have given, you will be extra careful in maintaining the records for these particular patients. Dr. Nilima, apart from this, do you really think that, for reassurance, taking adequate amount of professional indemnity insurance is something which we should definitely be considering before we start practice? Because what we used to hear from a lot of members is, I have a practice wherein the patients all trust me blindly. So I don't think I need that much amount of professional indemnity insurance. Does this hold value of today?
Which is the most robust policy. So I definitely say that each and every person should take an indemnity policy the moment he becomes a doctor and start practicing. It's like a motor vehicle act. आपने गाड़ी खरीदा तो आपको insurance खरीदना ही है. It is as simple as that. And insure yourself adequately. And again, we being present to AMC, the most robust PI policy is the AMC policy. Thank you.
Dr. Iyer, would you like to add something to this? I mean, any quantification of what is the minimum level that a doctor should take? I mean, a surgeon, physician, cardiothoracic surgeon, a plastic surgeon, what would be the recommended level?
The course of law is quite huge. It started with the Tamil Nadu judgment, and now we are earlier a lawyer used to win a case and he used to get a sanction of 2 lakhs or even let's say 40,000. It was that was also sanctioned. If it was in 4 or 5 lakhs, it was a big thing. But today routinely we see 40 to 50 lakhs, and quite often this is going to grow. The second thing is which has happened with the amended CPA. The filing of the litigations, even in the lowest court, it depends upon not what the compensation they are demanding, on the value of services that they have taken into consideration. So with that, in the district forum is up to value of services up to 50 lakhs and up to state commission up to 1 crore and beyond. If the value of services lower than, then you go to national commission. Now, most of the time, the value of services is not exactly 50 lakhs. So even if they file a case in district forum, they can claim a compensation of 10 crores or 20 crores. Nothing prevents the litigant. So what has happened probably in the last few months, I'm sure doctors would have noticed it, that the amount that is being demanded, 10 crores, 15 crores, 20 crores, and the minimum litigation may be 5 crores. And this really sets a scare for a doctor. Now, let us understand, even the person who has just entered consultancy and is just say 2 years or 3 years into consultancy can face such a huge litigation. It really is a big tension. If you say, as you say, the stress, you just started consultancy and you faced with a litigation of demanding 5 crores and you have taken an insurance only for 20 lakhs because of 25 lakhs. That is what the pressure state. And it's only the seniors who used to take 2 crores and 3 crores. But today, with the way the things are, the
higher and higher sums need to be taken. Dr.
Yes.
You wanted to add something?
Yeah, surgeons probably. Sorry.
How much higher? Yeah, sorry.
The surgeons probably, the way it is, the person who brings the intervention, like the surgeons or the imaging people who are doing intervention, they need to be covered much more than that person the stethoscope, like the general physician, etc. So the more the intervention, the more the surgical process, the more the complication, neurosurgery, cardiovascular surgery would hit the roof. Then definitely the oncosurgeon would be the next in criteria. Then the ophthalmology, because it is loss of vision, which is more important, where there is a lot of damage. So when you come to that, the surgeon definitely, the way I would go would be much more the senior people, much more, of course, today junior, senior, and today intensivist is also being hammered because of a lot of procedure, and that's with intensivist. So definitely we need much more cover. The junior most would definitely require 1 to 2 crore any day, and surgeons much more than that.
Yeah, Dr. Satish.
The ignorance about need for a medical legal policy. Even recently, I conducted a medical legal workshop which had postgraduate students, and I asked, do you know what is a medical indemnity? And 3/4 did not know what.
Absolutely.
And naturally, not even one of them had a policy, even though they were postgraduate students. So the only way to unfortunately, our regulators, NMC and all, ideally it should have been just like a vehicle license. Unless you have an insurance policy, you don't get to use this thing.
True.
Only
I think the time has come where even our postgraduate students need to be covered, and AMC has recently started this for the postgraduate students also.
This year, in fact, we participated in the undergraduate and postgraduate programs where we went and we made the students aware that the moment you come
True,
to
true,
practice,
true.
and obstetricians need to take a very
Absolutely.
not only the pregnant woman is going to sue you, but the child, when he becomes 18 years of age, he can also sue you back that you did not conduct my delivery properly. So you have
This has happened in the US, and we are sitting ducks as far as obstetricians are concerned. This could happen in the future, very near future in India also.
When you buy first time, you can also take the retroactive benefit, because a lot of times you start 1 year later and do not allow a gap between two of the policy. And a lot of times what happens, people say now that practice band kar do. So if you premium bhanega, please continue at least for 3-4 more years, even if you stop practicing, at least for 5 years will be more safer.
Absolutely.
Now, and Service Act, I think, cannot be done.
Yes.
Art Act, Service Act, NPP Act, Security Act. So for instance, for each person employee.
Absolutely.
And also for a person who is practicing infertility, can imagine the limits.
Absolutely, absolutely. So now, Advocate Jayawant, a particular patient came to me, and a few days later, he wrote me a letter mentioning that the treatment which he expected from my clinic was not up to the mark. So he makes a lot of allegations that starting from my reception, they were very rude. The hospital was dirty, and in the end, I did not give him enough time. So he's made a series of allegations. It is just a letter which he has written to you. And do you reply to all such letters? Or when you reply to this thing, should it be general reply, or you should answer rebut each and every allegation which he makes in this first letter that he sends to you?
In the first place, you must reply to any letter received from the patient. That is one thing. As far as the contents of the reply are concerned, it may not be exhaustive. In dealing with this reception, that is the general denial can suffice. As far as the medical treatment is concerned, the gist of what treatment was given to him should be given, because basic principle is, for whatever you have to say, if it goes to a consumer court or any other court, whatever is to be said in the court, there should be you should have said that at the first available opportunity. Nobody should be able to accuse you that you have not said this in the earlier reply and this is an afterthought. So the basic gist, particularly of your medical treatment, should be there in the first replies.
Yeah, so now Dr. Ashok, this letter has come to you, and what as a practicing obstetrician, what is your first step? Practicing in Mumbai, in being an AMC member, what should be the first step?
First, I will inform and call the medical legal cell and inform, because I have a professional indemnity through them. So I will inform them the content. I send them the letter also what I have received. I take their guidance while answering also the letter. And then as the case progress, already the medical legal cell will have a form. We fill the form. They also inform the insurance company, so that the insurance company is also aware. We have documented, so that tomorrow they don't say that you have not informed at the same time.
Claim intimation in time is required for getting your claims reimbursed later on, if at all it happens. This could be the first sign of trouble. So intimating the insurance company via your via AMC, if your policy is via AMC, and if not, evaluating whether you really need to shift to AMC also needs to be understood. Dr. Sujata, would you like to add something?
What I would also do is I would first fish out the documents, the OPD or the INDOR, because I need the proper story, what has happened. It may have happened a few weeks ago, a few months ago. So I would definitely—
Refreshing your memory to, so go through your own papers to try and refresh what has.
So that it helps me in creating that.
Absolutely,
response.
absolutely.
But whenever such issue occurs and when we call proposal or any member to proposal, first note down what has happened, this point wise, and then tell us, because you take your 5 minutes time, write down exactly step by step, and then we try to find out what are the issues which can create a problem whether references and keep other things ready so that next step we are at least prepared before having.
Absolutely. I mean, do we need to really take the help of a lawyer while replying to a general letter which comes from this thing? And is your response going to be different if that same letter was written by a lawyer on behalf of the patient?
It is always advisable as far as the doctors are concerned. Because as far as the patients are concerned, they just write a letter, whether they get the compensation, they don't get the compensation, doesn't make any difference. But when it comes to doctors, it's a life and death situation for them because their reputation is at stake. So I would suggest that it is always advisable that a lawyer is consulted before writing anything. And I would like to add one more thing. As far as what Dr. Ravi said, whenever a patient comes to you, even in an OPD, the normal practice followed by a doctor is you write the symptoms, you write the diagnosis, you write the advice and the prescription of medicines on the paper on your letterhead, and you hand over the prescription or hand over that piece of paper to the patient. If it comes to a case, doctor doesn't have all the records with him. I remember I had advised him to do this, but he had not done it. But you have no record with him. So either you should have a proper software or something. Whatever advice, whatever symptoms are recorded, whatever diagnosis is made by you, clinical diagnosis, whatever tests are advised, whatever is done by you at OPD also should be, you should have your record in your possession.
Very, very important take-home message. Maintaining of OPD records is something which Dr. Kapoor has been hammering in all our conferences, something which a lot of us still do not have systems in place for maintaining detailed OPD records. IPD records, I think we have a lot of improvements being made over the years, but a lot to do as far as IPD is concerned. Yes, Dr. Satish, you want to add something?
This is a comment and also query to what Dr. Jayant said about the initial letter that we received. So this point applies even when replying to a legal notice. So there is a thought that you don't reply and revert or clarify in all detail. Because
many a times you are giving away your defense this thing. So I mean, do not reveal all your cards to the patient in your reply. Make generalized rebuttals of all the allegations. It's a must. But I mean, sharing of the information as far as what are those points which will help you in defending yourself should this matter go to court, you need to be a little careful. And I think for that reason, we need the services of advocates like the advocate Jaiwan.
Letter, which is much before the legal notice has been received. The same philosophy can be used in.
Absolutely. I think Dr. Iyer wants to add.
Because we are discussing this point, just wanted to ask, is there a scope? Because I think calling the patient for a meeting personally, that would help to resolve number of misgivings or dissatisfaction that creates.
I think, I mean, somebody would anybody would like to answer what she has said. Is it wise to call the patient if she's made he or she has made some allegations against you? Is it wise to call him back to discuss this thing? Or when you are rebutting the allegations, just give a generalized at the end. In case you need any further clarification, please come and meet us. Will that help?
I agree with Dr. That if we encourage directly to the relatives, sometimes it will be misconstrued with them as if we are going to accept and we are going to come prepared as if we are going to ask something, you see. Right. So this is the way it is sometimes misconstrued and misunderstood. This is the way my view is that when we ourselves offer to call them, and probably ideally it is one thing I agree, we should always have the advocate in the loop. So of course we have to note on the chain of events and everything before we commit the case's litigation. What is more important, I feel we should also make the notes of the contributed negligence. Many times the doctors have advised the patients do this, do that, get admitted today, but they come after 4 days for admission, take your medication for 4 days, they take only for 2 days. This acts of contributory negligence need to be strongly documented by every doctor. And this acts small omissions on part of the patient. It goes a long way to put up our defense as negligence of the patient to adhere. So this is one important thing I would like to, and also many times the doctors
they don't have the time or they forget to take what is known as the informed refusal. Many times they say, do this, the patient refuses, they just make a note in their case. We should probably take in writing that if you do not do this, this will be the side effect. You know, if you do not get operated in time or do not need the blood transfusion or do not take chemotherapy, they keep refusing to do investigations, etc. That also is part of documentation. And lawyers need to always loop in. Is the way I feel is that though we write a chain of events and we can revert, but there are certain hidden points of law which any expert, however qualified in medical field, have a tendency. Let us be humble that though we know medicinal law, it's something in law which we may obviously miss, and this is very important. The point of law, the fact of law, could be missed. Why not run to a lawyer?
Absolutely.
Why have that thing that we know everything?
Absolutely.
So I think I would always safer, and for the patient, I would probably leave it as it is, in the letter. If you have any queries, revert. Then they show interest, then become here to study the patient and their body language. This is the way I think. Thank you.
With regards to a patient who during the course of the treatment itself is aggressive, is is hostile, and at the end of it, makes a fuss while paying the bills. Is it? Has the time come for the associations to maintain a registry of these such patients who are difficult? And Advocate Jayawant, can the associations maintain such a record for, can we start maintaining a records of patients who are needlessly abusive, who are needlessly hostile, who are needlessly refuse to pay their bills on time? And do we have any legal protection if the associations decide to keep such records?
You can keep such a record, but I don't think that you can use this record for in future not to treat him. This is something like no flyer list. You can't treat it. The airline not allowing a person to fly is a different issue. But doctor not treating a patient because of his past behavior may not be taken.
No, but sir, the point that I'm trying to make here is the name of a patient on such a list will make him, will be useful for a doctor in the future that this particular patient was earlier also hostile. So will that help?
What are you going to do like this?
No, share it amongst the members and use that data. This is something which I'm just trying to bounce the idea from this panel here, that the time has come for us now to be a little more proactive in trying to maintain such registries for the future. Yeah, I think I'm a little digressing from today's topic, but then this was something which I just wanted to highlight here.
If you cannot say that because of this record, I will not treat you,
then there's no point. Fair enough. Fair enough.
Just help our doctor members to be alert.
Fair enough. Only for timely referrals. Only for timely referrals to other centers, so that you get your peace of mind. That's it.
That probably, of course, these things are increasing, and you should make a list to be very polite for the particular treatment with the patient. And as far as recovery of money is a different thing, and treatment is a different thing. So they are two different departments. But I think in the computer, we put his number, his name, so that next time he comes, it becomes a shade, and there is a projector. We can use our own administrative. Yes, we can. Definitely.
I think it's the circulating that could be a problem. We could have it on our website, which is accessible only to our members about
True. Last year.
There is a way to go about doing this at the national level. There is a central government project which is called the next level, just like UPI for finance, there is UHI, Universal Health Interface. This has already been rolled out, proposals are coming in, and there are multiple, of course it will be beneficial. One of the things is insurance policy holders will be able to access patient data and decide on the premium and whether they want to give or not. So it is quite natural, it is our right to access data which is
absolutely
relevant to us.
Now it has progressed from a letter where he has made some allegations. It has gone on to a legal notice from a lawyer, and now you have received this notice from the consumer forum. It says that there is such and such patient has filed a case and is seeking so and so much damages from you. And what should be your response, Advocate Jayawanti? This here the notice comes for the hearing. What should be your response?
Within 45 days from the date of receipt of the notice, you must file a detailed statement. Giving basically, I prefer to do it this way, that give brief facts of the case. So whatever happened from the day the patient came to you till the end. And then make reference to all the medical references and whatever treatment was given to you and how that particular treatment was in accordance with the proper medical protocol. That should be recorded. So basically to show that there was no negligence on my part. Whatever I have done is in accordance with the medical protocol. And before that, I possess the requisite qualifications, the expertise and the experience to treat a patient of this type. That has to be, everything has to be recorded in the written statement properly, in details.
Ashok, would you like to add something on this? Yeah,
Nilima. Supporting you where others have gotten acquitted. Those case laws also you can take help of, because the judges generally depend upon the precedents which are set.
Those case laws can be cited at the time of arguments.
Not
as far as the written statement is concerned, basically the reference should be made to the medical literature and the medical protocol which has been followed by the court. That means yes, at the case of argument, judgments are produced.
Is it wise to add opinion of a senior doctor in your written statement itself along with it? Is it wise?
You can do that also. It can be done. Or you can annex the opinion of the doctor to the affidavit of evidence, which you file at the next stage.
The next stage. Okay. Ashok, you wanted to say something? Oh, yeah.
Similarly, documents related to the treatment, at what stage do you think they can be shared?
At the time of filing affidavit of evidence.
Okay.
Along with that, we file all the documents.
Not in the regular.
Not we refer to it, and in the end we say I crave you to refer to and rely upon these documents.
Sir, after what stage you can't add documents? Or we can keep adding to the.
If you see the stage of producing the documents is filing affidavit of evidence. Along with that, you refer all those documents in your affidavit of evidence and annex the documents. Subsequently, if you want to produce any document, then
take the leave of
basically you have to show to the court as to why this document could not be produced earlier. And if you give a cogent reason for not being able to produce these documents earlier, court will definitely take those documents on record even at a later stage.
If you lose the case now and go up the high court, can you still add?
No, that becomes difficult. That becomes difficult. That becomes difficult. Yes. Yes.
Now, Advocate Jayawan, we had in the morning a lot of this thinking. The courts have, even the consumer courts have been very liberal in condoning the statutory limit period. I mean, can we as an association do something about this? That I think Justice Tavde mentioned about it, that the complainant needs to give a reason why he has the delay. As an association, can we do something about this liberal?
Because that's a provision of law.
Okay. Now, we unfortunately are in a situation where the consumer, the patient does multiple multiple forums searching. What he does is he files against you in consumer court. He also files a criminal case. He also files a case in the medical councils. If it's a lady, she will also file in a women's commission. So all these multiple forums. Now the next forum which I would like to move on from the consumer forum and for my questions is what happens when you get a notice from the Maharashtra Medical Council. The Maharashtra Medical Council sends a letter to you that this particular patient has complained against you about the treatment which you had offered. What should you do? Yeah, Sujata?
Yeah, so the procedure that is followed in the council is whenever there is a complaint letter which is coming to the council, the registrar speaks to the president and sends the notice, the complaint to the concerned RMP. The RMP is supposed to answer in a requisite period of 15 days, not exceeding 60 days, something like that. I don't know whether they follow that period. But once the RMP answers and if that answer is satisfactory, the explanation is satisfactory, then the president may forward it to the executive committee, which also deliberates on that and gives their opinion. And following that, they forward it to the president and the medical council. Once the council decides that this case is worth taking up for an inquiry, they schedule an inquiry. And accordingly, they send the communication to the RMP and they set a date for the inquiry.
Dr. Shukla, what has been your experience? I mean, you are in multiple associations. What has been the general trend amongst the medical councils? I mean, every complaint which reaches this thing, are notices being issued to the doctors regarding this, and can we do something about it without primary screening?
Either they fight with NGO or advocate their guidance, they will complain on all forums because they want to attack on all forums. Wherever they get some positive judgment in favor, they will use on the other platforms. So they will go. The problem with Maharashtra Medical Council, which already a lot of associations were requesting, is first is they give too short period. 15 days is too short period when consumer forums is 45 days. Here at least so we have to write a letter, ask for more time, which has so that's a routine format. They give. But they are not changing for the move. Second is there is no screening method because a lot of patients during COVID era, because of money financial issues also, they have started targeting the Maharashtra Medical Council and they have complained to the council of unethical practice, excessive charges, and the council has sent a letter to the doctor. The moment the council sends a letter to the doctor, doctor becomes panicked because council ने चिट्ठी भेजा है तो आपको अभी टेंशन है. So they should be some screening method. Each and every complaint should not be, but that's their way which they follow from so many long time. And then as Dr. Sujata told, the next step is that we have to answer, and then once they will call you for a meeting and they think there is your answer is not satisfactory, then they will refer to the ethics committee, and the ethics committee, if the matter is of Mumbai, the ethics committee would be from out of Mumbai, and then there again the issue happens because the outside doctors, they are living and here the practicing, lot of difference is there. And sometimes things which I can't say, but things happen. This also with under the guidance of the lawyer, because every point of the complaint has to be regulated.
Yeah, so it is again, I mean, it is definitely, I think the take-home message is it is definitely advisable. Even in the medical council notices, if you are very confident that you are able to answer all the allegations against you, then too it is safer to take the opinion of our panel of lawyers.
So that's the reason members don't have to worry because the PSL not only help in answering, they also they can follow the cases, and if the case go beyond, we have good education panel who come and help and rescue the doctors.
As far as MMC proceeding before MMC are concerned, I have been regularly appearing before MMC, and I would not go into details, but I would only say if MMC adopts a proper professional approach, that would really help the doctors. I don't say that hiring doctors should be protected. If there's something wrong, that the proper action should be taken. But if they adopt a proper professional approach in dealing with the complaints, things would be much better for the doctors. That much I will say. I cannot go into details at this point.
I think I completely agree with Advocate Jayawant. I mean, as far as the councils are concerned, they are our people who will actually decide whether we can continue to practice or not. So what Ashok said about notices from the council now being really very scary for us because it really affects your day-to-day practice. So we really need councils which will be more proactive in screening the cases number and before sending the notices as what Ashok mentioned. And we need councils which will be actually, I mean, there have been instances where the cases have been filed. The litigants do not come to on the time of the hearing, and the next hearing the doctor leaves his practice, goes and sits in the office, and at the end he finds that his case either did not come up, or if it came up also, the litigant was not present. And then is there some way that we can change this, sir?
Before that, I know one case, I was attending. Notice was issued to the doctor on the basis of a complaint made by a patient that I had issued a check to the doctor, but she did not deposit it in her account. Now, how is the MMC concerned with this aspect? MMC has got nothing to do with this. MMC has to see whether it is the medical negligence or no. But on this point, the notice was issued, and ultimately the doctor was exonerated. That's a different issue. But basically, issuing this notice on this count was itself wrong.
Yeah,
One
Dr.
question I wanted to ask, based on what you said. In case the MNC, which has got all the powers of examining or taking over the case, like a civil court, if they do not follow the prescribed way of inquiry, what recourse does the complainant or the doctor, RNP have? Does he have any recourse?
If an adverse order is passed, all these grounds about the functioning of the manner in which the proceedings were conducted can be placed before the High Court.
I think we have many instances where Advocate Rui Rodriguez has been able to get our members exonerated because of the lapses in the hearing. Dr. Satish, your experience as far as Karnataka Medical Council, is it the same or is it better?
Two common things. One is, they don't allow they try to have the doctor RFP without their knowledge. The thing, if there's a trial or inquiry in person. So the doctor is expect. I wouldn't say they say don't bring your lawyer, but
is discouraged to bring his lawyer.
But now the new NMC draft, now they have clauses where they say no lawyer will be allowed. They feel because lawyers come, the cases are going too long. Doctors come, it will.
And one other
unfortunately,
NMC comes into force where they have very clearly mentioned that you cannot get a lawyer to represent you. So that will be very detrimental to us.
So I think so more medical legal conferences to make our members more medical legally aware, because now they have to stand in MMC alone.
work for you next year, Ashok.
One more funny thing that the state medical council did is they sent an doctor sent an RTI because to collect an appeal and so on. They said we don't come under RTI because the state government is not giving us anything.
Just a response to what Ashok and Nilima said, though it is under review, I don't think it is still passed by anyone. Medical legal consultants will be the next generation who will be representing. I think that would be, because that is a recommendation that we have given.
Now we move on from the medical council to the next very, very dangerous forum is filing of a police case. Now the patient files a police case saying that such and such doctor, because of his negligence, my relative or my own health suffered. The police sends a notice to you. What should you do? He sends a notice to you to come and join to give your statement. He has made a complaint.
Have to go to the police, have to summons or whatever they send, we should report to the police. We cannot disregard any notice from the police, and then if you have to conduct an inquiry, we have to cooperate with them.
No, but is it really, is it mandatory for you to go to the police station, or you can request them to come down and take your statement?
Because very often the doctors naturally, they are very, very busy.
Correct.
Let us be honest about it. They are genuinely busy and their presence is needed for emergency cases. So definitely we can tell the police that because of this, can you come over, and definitely the police, they cooperate. They come over, then they have their person, and
we would rather avoid the police presence in our clinics, and we would rather cooperate with them at the police station.
it sends on that means on convenience. Right? But they definitely,
In between ways at the hospital where you practice. certainly not at all.
And before going to the police or speaking to police, please contact your PSL, inform them that you have got such notice because and what was the case, tell them, and then because you don't know what statement also they will guide you because a lot of time police will try to put words in you and write your statement in Marathi.
Yeah, what happens, I mean, if the written statement, which whatever you have said, the patient, the police is recording it in Marathi. You are not very fluent in Marathi. What do? Should you sign it immediately there or you ask them for a copy before you sign it?
We can definitely go through it, but invariably we have to end up signing. That is what I've noticed. They expected and they don't give a copy. We can take the first photo if you want. That is there. That is there. We can always have somebody knowing Marathi who's supposed to us to interpret what they have written and but they make us. We have to be very careful because this later on all this goes when it goes to the expert opinion.
True.
To JJ hospital, everything goes. So we have to be very careful what we sign.
Absolutely.
Caution the doctors, please read every word, every full stop. Everything goes to JJ for the expert opinion. And later on, we don't want to explore them. No. We expect it to know. Expect
There's
to
one
pay.
simple way I used to circumvent this. So once the whatever thing was done, went home, I sent an email to the official police station email ID to the commissioner. And later I wrote whatever I wanted with reference to all this, don't understand Marathi, whatever, blah, blah. And later through RTI, when I got a copy of the file, I realized that they had attached my email verbatim as a statement. End of the doubt.
Okay.
So the time period when we are called with the police, in what period that we should, are we expected to, report to them?
In a reasonable time.
So that can extend to.
A few days.
So we can consult our respective lawyers, create our own statement in our own language and then give it to them. So I think
that you can prepare a detailed statement and submit it to the police that this is my statement.
Absolutely.
I think that's something which is very, very important that you can take a pre-written written statement about the facts of the case and you can give it to the police and say that this is what. Absolutely.
The complaint also. Do they give us a complaint?
So and so patient has a complaint against you. That kind of like you get summons you get from the police. As far as that patient is concerned, whatever are the details, prepare a detailed statement. Whatever, how there was no negligence, and to submit it to the police and take their acknowledgement. That's the
Now, unfortunately, there has been a death of the particular patient and the police tell you that a complaint has been lodged. Is it wise to go to the police station there without a lawyer? Is it wise to take anticipatory bail? What are the pros and cons of that, Advocate Jaiwan?
See, what I feel is going by the Supreme Court judgment, police cannot register an offense without getting opinion from government hospital. So there is no need to rush for anticipatory bail.
Absolutely. And Ashok, you would like to add something to that?
Sometimes, approaching the court for anticipatory bail can backfire also.
Absolutely.
Because maybe the police was not that much thinking and case was not going on that side. And because the anticipatory bail, now the police also has to come and oppose the anticipatory bail. And that time, maybe sometime government or other parties also might join. And then you might not have much space to come out. Maybe this case or any other case.
So I think every practicing doctor needs to remember what this thing is that as of this thing, most of the police stations in our Mumbai area have been told about the Jacob Martin judgment, as a result of which they are quite efficient in sending it across to JJ before. But the risks of this will still remain. I think as Advocate Nafde has mentioned, and we, at AMC did try to codify this as what Advocate Nafde informed. And I think I really need to inform the House that with regards to this Archana Sharma case, which was where this young doctor from Rajasthan committed suicide. Our Association of Medical Consultants did try to file a PIL in the Supreme Court with regards to unfair arrests, illegal arrests, happening across the country. We almost had a case record of 16 cases. The case was argued by Advocate Shekhar Nafde himself. Unfortunately, I mean, the case came before the Supreme Court and they said ki this is when it is an individual case with regards to individual relief, you need to go to the high courts. The Supreme Court was not willing to convert it into a general public interest litigation. And Advocate Shekhar Nafde was actually kind to appear pro bono. He did not charge any of his professional fees. He appeared for us free of charge. I think there was one point which we should have highlighted when he was here, but we will convey our appreciation on behalf of you once again to him, that the members present here in the audience did appreciate his services.
Question is very important because a lot of members, when they have this threat, they always question why not get anticipatory bail. They tell the cell or officer anticipatory bail and move because they are always worried to get arrested.
True. Now, I think we are moving a little this thing because we are running short of time. Only two special acts with regards to which I think especially gynecologists and radiologists need to be very careful about is the POXO Act and the PCP-NDT Act. So the POXO Act has really created a lot of problems for us. I mean, advocate, yes, I think you are also an advocate. So, Dr. Shukla, I mean, you get a notice from the patient, from the police station that a particular patient came to you, you examined her, you found her pregnant, and you did not inform her because subsequently she was found to be underage. Now, what should you do?
Now, the POXO Act, the section 19 says mandatory information as police has to be informed. A lot of time, doctors sometimes misinform, whatever reason is. The moment they come to know, they are informed, but then later police because they have not informed, so they try to punish them under section 19. But section 21 says 6 months imprisonment or fine. Now, such things you have to immediately inform your PISL, because if you go to the police station, sometimes the police will directly arrest you.
Yes.
And they will then directly use criminal offense. They will arrest you. Then you have to go through the process, get a bail, but then 24 to 48 hours will be in the jail. Even if you are not negligent, whatever mistake or intention was not there, but the police will say you prove. We are only there to put the things in place that you prove to the court that you didn't intentionally miss it. So you have to inform, and if you miss, you will receive the letter. Please inform the PSL. They will appoint you an advocate. Stick to the advocate. Don't go to the police station till your advocate says or accompany or tells you go and take a bail and keep yourself safer. Sometimes the police don't make you co-accused, they make you witness. So that also you have to see with the papers and be in touch with the PSL, because sometimes the police says, Doctor, आम्ही तुम्हाला आरोपी बनवतो, आता तुम्ही आमच्या विरुद्धच तक्रार टाकली.
What happens? I mean, the patient has come to you. She says she was 19. She, you treated her accordingly, like any other patient you would have treated. But subsequently, I mean, she goes and there is a marital dispute, or there is a breakup between this thing, and then she goes and says, I did not, I gave my age as wrong. How can you protect yourself from this?
See, whenever you get a patient borderline, you feel better ask for an ID proof. Now, Aadhaar card is a very commonest available thing. I recently had around 10 days before a call from XYZ place where the Aadhaar card was showing 17 years, 11 months. But then the patient told me there is a mistake in the Aadhaar card. But immediately within 1 hour, the husband was able to produce the school living certificate with the right date. But still the doctor I told the doctor, see, we don't know the Xerox set. You be ready, inform the police. After say 6 hours, same day, he got an Aadhaar amendment that receipt also. And I have gone to the corporation and I have applied for the Aadhaar rectification. And this is the Aadhaar rectification. But good about the medical conference, the doctor was so vigilant. Half an hour he was calling up and he told the husband, if you don't come by this time, I will inform the police. I have already entered in my medical legal buster and I am waiting for your ID proof. So please ask for the ID proof. A lot of time we are in hurry. There is an issue which Dr. Kapoor said when the patient gave, the gynecologist gave mifepristone, and after 4 hours the Aadhaar card came and the patient was less than 18. And then the police has now made the doctor co-accused. What was the hurry of starting the MTP process? Why did you wait? Now you keep proving. Even if you are good in your hand, then the police says you had taken money from the husband's side, and that's the reason you did this with the intention of destroying evidence. So the whole case scenario goes. So don't be emotional, ask for the ID proof.
I think as far as radiologists are concerned, this is something which is again, which is a problem, which is a lot of some of them cases which have come up before the medical. No, that the patient was referred to you for pain in abdomen. And you found out that there was a 6 weeks pregnancy. You gave the report. The patient, I mean, you did not, in your busy radiology practice, you missed out on the age of the patient. You did not inform. Subsequently, the police comes and tells you that this patient was underage. Why you did not inform? Any defense to your this thing for that, for such cases?
Basically, first you have to inform. You can't escape because it's a very strictly applicable, and they say this has been made only to protect the woman and so that every sexual offense gets reported. That is even this act came in picture because before there was n number of acts. Now, whenever this comes, you can try to defend saying that I had asked for the Aadhaar card, they told I come after 2 days and called up the gynecologist. But the law says each and every person who comes to know. So you can't say also that the gynecologist would have informed. If you have a documentary evidence, he has informed, then only. Otherwise, please inform the police chowki or call 100, send an email, attach it, and be safe.
Nilima, this is a particular case which came to me yesterday itself. This doctor is a doctor in a government hospital in a rural place in Maharashtra. Patient came with her husband, married lady, delivered. The patient was absolutely fine. Child and the mother went back. On the paper, they wrote it as 9. I mean, the age given was 19 years. Subsequently, this lady had a dispute in the family, and she was murdered by some relative of the husband itself. And then subsequently, they found out that her Aadhaar card had mentioned her age was 17 when she had delivered. That was that too 3 years back. So now they are asking her to appear. Why she did not ask for Aadhaar card at the time of admission? Is it really mandatory to ask for Aadhaar card for age proof in all patients? Is it now the time come for that?
First of all, Aadhaar card, very latest judgment is saying that Aadhaar card can no longer be used.
Absolutely.
So do not rely on Aadhaar card. There are other ways and means of getting your age proof, but very difficult again. So still we don't have any other option, Aadhaar card, something. You should have some evidence that you have.
No, but is there any government circular, advocate, or any government rule which mandates that age proof should be collected for each and every patient admission?
No,
absolutely, that's what I'm
saying. Like that.
Sir, only thing here, in one of the similar issue in some corporation, we were able to defend saying that the registration counter who first sees the patient wrote 19. That is the reason the doctor there felt the patient is over 18. He thought
absolutely, it's an administrative problem, not a problem of the defense.
See, first and foremost, doctor is not the investigative agency.
Absolutely.
We are doctors. What we document is what the patient tells you. In case of abortion, to be borderline cases, where you're married, not married, even if the patient is married and she's underage, the POCSO Act overrules everything.
Yes.
So whether she's married under whichever marriage act, you still have to inform.
Absolutely.
So that again is good up. Unmarried patients, younger patients who come to you with pregnancy, what we do is we ask the partner also to come and we ask the patient herself to write in her own handwriting saying that this is an act which is this pregnancy is resulted out of a consensual act with so and so. We make her write, and not only signature, we also ask her to put a thumb impression. Because tomorrow the patient may say this is not my signature. So we put the thumb impression as well. We do that with the male partner also because sometimes women tend to misuse this against the male. So we also ask the partner to say that yes, he had participated in this consensual act which resulted in this abortion, and the decision to take the abortion is entirely the females and no one has coerced her. So we have to protect our males too. So these are the few things that we do take care of.
I think I'm getting signals from the organizers that we have exceeded time. I mean, one last word from advocate from
certainty haven't yet woken out to the fallout of this toxin. For example, this example that Dr. Ashok gave. See, if there's someone with 8 weeks amenorrhea who comes, and typically the thought is, what is her age on the day that she has come? But the point is that on the day when the physical act has happened 8 weeks ago, it is if the doctor fails to realize this, it is failure to report a physical assault. This is one. The other, there is a ambiguity of, there's a conflict of personal law versus POXO Act. Right now, there are 3 High Court judgments. First was by the Punjab Haryana High Court, kept that the Muslim personal law stands superior to the POXO Act. And then I think Kerala High Court and Karnataka High Court
have ruled to the contrary.
Yeah, to the contrary.
Yeah, but still.
The point is that the court absolutely. You are not up to you to decide. Alright, the act is in place, follow the act, the courts will take care of the marriage act and all that, and it's for them to give the decision, not for us to do it.
So I think,
it is better the doctor.
we can go on and on.
Let the court tell the government, please bring the amendment that best way as the LPT Act. The government was asked by Supreme Court and they did amendment. But till then, why all colleagues please follow.
I think we can go on and on as far as optimizing our response to these medical legal cases are concerned. What Ashok mentioned, take a good insurance. A red flag, raising of the red flags, identify the patients who are more likely to be potential litigants, and do take the help of your associations, attend medical legal conferences, and keep yourself up to date with medical legal this thing, and documentation is what all of us have been screaming at the top of our voices in all the medical legal conferences. And I think we really need to hammer this into all our members that this is really very important to take it forward. With this, I think I really like to thank the organizers for giving me the opportunity to moderate this session. And I really need to give a big round of applause to my panelists for answering those questions in a manner which I think a lot of take-home messages could have been taken by the audience.
One more take-home message from everybody is please stop medical jousting. You do not know what decision that doctor has taken under that circumstance. You are no one to judge that. See the patient according to what you think is right, and patient safety has to be the end goal of every doctor. Thank you.
A big round of applause, please, from all the audience to our wonderful panel and to the moderator.
From morning, we are talking about the laws and consumer protection and all. We can't forget the fact that the patient enters our cabin as a stranger. We are the persons who have the entire knowledge and power to facilitate his journey from being a stranger to a reassurance level, because that is the only way he is not going to return dissatisfied. And if that happens, most of the things are avoided.
Thank you so much, Sujata and Dr. Suganti, Advocate Ashok, Nilima, and Dr. Satish. And I'll request all the panelists to come forward for a group photograph with the moderator. Please come forward and let's have a group photograph with them. And I would request, can we have a group photograph of the panel? And I'll request first our president, who's doing a double role as panelist and as the president. And I would request Kapoor sir to come forward to first felicitate our moderator, and then we'll felicitate all the panelists. Moderator, sir, please. Sir, we would request Nilima and you to felicitate our moderator. All the and Nilima, would you Sudhir, you have to felicitate Nilima first.
Oh yeah, sure.
Yes.
My privilege.
Nilima's first. Thank you. I'll read out the names. So Nilima and Sudhir Khanna, Dr. Satish Bhatt. Advocate Jaiwan. Dr. Suganti Iyer. Dr. Sujata Rao. And just round of applause. Thank you. Thank you so much. I have a very pleasant task of just 2 minutes for the vote of thanks. We would like to thank the team from Nanavati Hospital, especially Dr. Ashwini, who has cooperated with us for the entire program and done a wonderful job. Lalit Kapoor sir, who has been the inspiration for this entire program and worked with our president, Dr. Nilima, Dr. Kishore Adyantaya, FAMC Secretary, Dr. Sudhir Nayak, Chairman, Medical Legal Cell, and Dr. Ajit Desai, Convener of the Medical Legal Cell. All the wonderful speakers who have come and participated. The team, Finovate and Pranob, who has done a good job with the audiovisual. And we thank all of course, you, the audience who has been here, and our team members from AMC office.
Let us not forget Dr. Ashwini, who is the MS of this hospital. And though she could not be present today, she was there 3 days before trying to set up everything. I also want to thank the audiovisual guys and the console guys who came and did the dry run. That was fabulous job. Thank you so much. Also, thank you to Chetan for having given us a massive concession on the food and having arranged the food so well. So thank you to everybody. Have I missed out anyone? No. Thank you to Dr. Reena Vani. She's been the program committee chairperson and she's handled the whole thing so well. So thank you, Reena. Thank you.
Thank you so much. Thank you. Pranav, Nilima ka mera photo. Yes.
Breakfast from Ines Pino, you know.
He's making you lose weight, I'm sure. Yes. Thank you, lovely to meet you. Come, we'll take Yes, yes, yes. Thank you so much. Send me the pictures. My brother will pictures. A lot of the consultants.
He does all this. Yeah.
I know you all have given us a special OPD. I think that's been really great.
Close. Yeah, Dr. Satish spoke well. You covered everything.